All right. Business before the Honorable Chief Judge and Associate Judges now sitting on Banc for the District of Columbia Court of Appeals. Draw near and give attention. God save the United States and this honorable court. This honorable court is now in session. Please be seated and come to order.
Good morning, everyone, and welcome to the District of Columbia Court of Appeals for this en banc sitting in the case of Sergio Velasquez Cardozo versus United States. I wanted to welcome everyone, including our special guests, students from the Washington College of Law at the American University. As you may notice, the judges are not wearing masks. We opted not to wear masks so that the attorneys and parties and folks in the courtroom could hear us better and better tell who's asking which question when the questioning gets exciting. Counsel, you are free to unmask yourselves when you're at the podium, but we do ask at this time, in accordance with our court's masking policy, that those seated in the courtroom or not actively speaking at the podium remain masked. As relevant here, in this en banc case, the appellant was convicted of kidnapping after he grabbed and fondled a complainant on the street. Appellant appealed his kidnapping conviction, which a division of this court affirmed, and this court granted appellant's petition for rehearing en banc and requested that the parties brief the sufficiency of the evidence as to appellant's kidnapping conviction. In particular, we requested that the parties brief the statutory elements of an offense under the District of Columbia's kidnapping statute. We also granted the Public Defender Service of the District of Columbia's motion to participate as amicus curiae in support of appellant. And I would like to take a moment to clarify how we will proceed with the argument. We granted counsel for appellant, Mr. Kaplan, 45 minutes of argument time. We granted Public Defender Service counsel, Ms. Schneider, 15 minutes of time. And we granted counsel for the government, Mr. Coleman, 60 minutes of argument time. So Mr. Kaplan and Ms. Schneider, if you, as you come to the podium, could clarify what, if any, time you'd like to reserve for rebuttal, we'd appreciate that. And with that, counsel, are you ready to proceed? I would note for all counsel that the podium does adjust up and down, and so take a moment to get comfortable and to position the mic so that we can better hear you. Thank you.
Good morning, Your Honors. My name is Matthew B. Kaplan, and I represent appellant Sergio Velasquez Cardozo. And with the court's permission, I'd like to reserve 15 minutes of time for rebuttal. Your Honors, the government's central argument in this case is that the kidnapping statute in this jurisdiction is clear and unambiguous.
Mr. Kaplan, I know that we are going to pepper all the counsel with questions, and if you don't mind, I would just like to jump in and get your further thoughts. But you know, the model penal code statute differs very much from the language of the District of Columbia's statute because it does have a requirement that the holding and detaining be of a substantial duration. And here, on the facts of this case, I think the officer who witnessed this event said that this was a split-second grab and grope. Can you tell us how, based on the language of our statute, which has been interpreted strictly by our prior Richmond case, what latitude we have to change that language, to read in any durational requirement, or to interpret it in a way that might avoid the result that happened for the split-second holding?
Yes, Your Honor. I think one of our fundamental points is that the statute is ambiguous. And, that's not unusual for a statute to be ambiguous. It's simply not true, as the government contends, that you can look at the words of the statute and readily understand what kidnapping is. And when courts interpret an ambiguous statute, they use a number of tools to decide how the statute should be interpreted.
Sorry, is your argument that the plain language, sorry, over here, is your argument that the plain language is ambiguous, or that given the sort of capacity of the statute, that's what creates the ambiguity where the plain language might not otherwise?
I think both, but the plain language is ambiguous. For one thing, you have this very strange double definition to two-pronged definition. And also, even aside from that, the definition uses words that have very different, you can have very hold and detain, for example. You can have very narrow definitions of those words or very broad definitions of those words.
Can I ask you, are there any definitions of those words in isolation, just like looking at dictionaries, that have some idea of a prolonged period of time or length? There are definitely ideas like custody or other concepts floating around, but are there dictionary definitions of hold or detain in isolation that carry with it the idea of prolonged or substantial or some idea like that?
Yeah, of hold and detain, yes. For example, and I think these are in our brief, there's a definition from Merriam-Webster's dictionary. Detain means to hold or to keep in custody.
That gets the idea of custody in. And so maybe you have a two-step point, which is, well, some of them use the word custody, and the word custody implies duration, but are any of them just like directly duration, or are they all more complex lines of reasoning about duration from ordinary or kind of ordinary language in isolation?
To my mind, custody implies a duration more than just a brief.
Maybe not, but I'm just asking first, other than the word custody, are there other definitions of hold or detain that carry with them some idea of prolonged or substantial duration?
I'm not aware of any definition that explicitly says it has to be for a prolonged period of time.
And so you're going to say you think custody implies duration. Is that from dictionary definitions of custody, or what makes you think? Custody definitely carries with it the idea of legal authority. Mm-hmm. I get that, but what makes you? What's your kind of line of thinking about why custody implies prolongation?
To my mind, at least, custody, you have to be under the control of it, and some of the definitions say this, something akin to imprisonment. But
certainly for in Miranda, that, for example, is that concept is used in Miranda that's not understood that way, or in dictionary definitions, or I'm just wondering kind of the chain of kind of ordinary language reasoning you have. I understand there are many other lines of reasoning you have about how to interpret the statute here.
And I guess our point would be is that custody can and often is understood as you're holding someone for more than a moment for some significant period of time. But one point I'd like to make is that the leading Supreme Court case on this issue is Chatwin, and Chatwin makes the point that we shouldn't be really focused. That said, we shouldn't look at this as an issue of like lexicography. We shouldn't be focused on the dictionary definitions. We should be focused.
In Chatwin, the holding or detaining was unquestionably for a fairly substantial period of time, right? I mean, it was a couple months. And the court wasn't addressing the duration in that case. It was addressing the voluntariness or consent to the holding or detaining. So I understand that Supreme Court dicta may be persuasive to us, but why should we rely so much on Chatwin when that's not at all what the court was addressing there?
Well, I'm not, you're right, Your Honor. Even if it's dicta, I think obviously Supreme Court dicta carries some weight. I'm not so sure it was dicta. What the court was, the issue there was what was custody? What was the issue was because of this woman, the victim's limited mental capacity and her age in that case, was there a detention at all? Was there a holding at all? I think was the court was focused on. And the point of the court was, we don't look to the dictionary or make these, we look at the statute in a broad sense. And the purpose of the statute is to criminalize it targets major.
You're using the word major. I mean, how much do you like Chatwin? Chatwin said, as duration goes, appreciable. So if you really think, if you like Chatwin, do you think that's the term we should be using? The Supreme Court's really already told us what term we should be using.
No, and the government makes the point that one of the dictionary definitions of appreciable is literally that you can appreciate it, you can feel the sense that it occurred. But I think,
well, I'm just asking, leave aside what appreciable would mean. The first question is, if you're saying we should be guided by Chatwin, it's not a holding. I mean, it's not dicta, and in any event, we should be guided by it. It would seem that the logical consequence of that is that with respect to duration, we should pick the word appreciable, whatever that might mean. Then we'd have to figure out what that means. But is that what you think we should be doing, or do you really not like Chatwin that much?
I would. Our suggestion would use substantial, which is the word the model penal code uses. And I think that's the whole point of Chatwin. They use the word appreciable, and one of the definitions of appreciable can be significant. But the whole point.
What's your best definition for substantial?
I'm sorry?
So what's your best definition for substantial?
Our view, Your Honor, is that in the kidnapping context, substantial should be defined or informed by the test set out in Government of Virgin Islands versus Berry. And
that test is very atextual. If you had to get rid of Berry entirely, how would you try to define substantial in light of the actual text we have?
I'm sorry, if we're setting aside Berry, did you say, Your Honor?
If you were setting aside Berry, if you didn't have that, how would you define substantial? Because that test and those definitions, the factors really stand outside of the text here of the statute.
But substantial is something that juries are sometimes and judges are sometimes called upon to interpret. And there's no doubt that it's not an easy task. It would often not be an easy task to decide what is and what is not substantial. I guess our point is, well, first of all, is that under almost any definition of substantial, what happened in this case, the momentary touching of one person by another, that's not substantial. So,
I mean, I'm not sure if that's right. Why, substantial to who? You might ask, and the jury might think, well, it was probably substantial to her. She was grabbed, she was groped, and it was a substantial infringement on her liberty. I wonder if substantial really gets you where you need to go.
Well, substantial informed by the Berry factors is what we would suggest. And
but Berry, if I'm not mistaken, doesn't require a substantial period of holding or detaining anybody. It just says, so far as I can tell, here's some factors to consider. How long they're detained or moved. Is it incidental to another offense? Whether or not it created an independent danger that was imposed by the separate offense. All fairly strange, but you could say, well, did it create a danger to her? Well, you seem to be trying to commit he committed and was convicted of third-degree sexual offense. I guess it was inherent in that offense, but why do you think that matters? Let me pose a hypothetical. Have you seen or read Silence of the Lambs?
Seen the movie here.
Buffalo Bill was this character who kidnapped women and wanted to make a dress out of human skin from them. But then he held them captive so he could starve them and then kill them. Their kidnappings were entirely incidental to their murders. I mean, he didn't care about the kidnapping. That was just helped him make the dress he wanted to make. But why would that be a factor in favor of saying he didn't kidnap them?
You mean, in other words, why does the fact that another crime occurred inform the definition of kidnapping?
Yeah, if I hold somebody for an hour just because I caught them breaking into my car and I'm waiting for the cops to get there, that might be a kidnapping. But if I hold them for an hour to torture them, if I just want to give them 1,000 little cuts with razor blades over that hour, Barry would seem to say the fact that it's incidental to another offense makes it less likely to be a kidnapping. That strikes me as a surprising result, and I wonder what sense you make of that factor in the Barry test.
Well, I think sort of the underlying premise for that reasoning by the Barry Court and by the other courts of appeals that have followed it is that that was, and not just Barry, but also the state courts applying their own state statutes have reached similar conclusions, is that was the legislative intent, that Congress or the state legislatures would not have meant, for example, every single assault to be a kidnapping. But that is an unusual way, I'll admit that, to define a crime. But there's nothing inherently improper by defining a crime.
It seems like it's not terribly, it seems like it's not terribly helpful, right? If the concern is here, we've got this kidnapping statute and it has this ambiguous language that lends itself to absurd interpretations, then adding in some test that has this kind of mushiness of, well, let's refer to the existence of other crimes that might be present here. It's just a weird way of defining a crime with any clear boundaries, right?
It's an unusual way. I think it makes sense in this context.
I mean, do you really think it's helpful, I guess, is my question.
I do, Your Honor, because I think the concern that Barry expressed and the state law cases expressed is that we don't want, for example, on Howard, it was a robbery, and every single robbery should not be deemed a kidnapping.
Let me just put a finer point on it. I mean, you want the fact finder, well, first the government in charging, and then the fact finder, be it the court or a jury, to kind of speculate as to any other crime that might have occurred during this incident and think, well, it's actually incidental to this other crime, so therefore we don't think it should be kidnapping. It just seems not an efficient, not a clear way of getting about what I thought you were trying to achieve, which was to say, look, this is a statute that was enacted in 1933 in response to the Lindbergh baby kidnapping, right? Which was a national scandal. And it was a really serious event, you know, and it has a 30-year maximum. It's a Class A felony. It's one of the few predicates for felony murder. This is not for penny ante stuff. And we need to make that clear. I thought that's what we were trying to that's what you were trying to ask us to do, but I'm not sure how consideration of incidentalness gets us there.
I guess I would say that, you know, as I mentioned, one of the tools that courts look upon in interpreting an ambiguous statute is the case law. And Barry, or an approach like Barry, has been the almost universal way in which courts have approached this issue of very short kidnappings or kidnappings which essentially overlapped with another offense. Certainly the Barry test is not perfect.
I'm not sure if you actually did a survey that the Barry test is kind of universally beloved. My sense is that there are lots of different factors that courts consider, or that legislators have considered, and that Barry just kind of takes its own assortment of those factors. You know, people might say that they're following Barry, but it's not clear to me from looking at the case law that Barry is really the universal agreed upon standard for kidnapping, for discerning what a kidnapping is.
I would say that, Your Honor, that I think most of all the federal circuits that have addressed this issue have adopted Barry. There's not many, but 3 or 4 circuits have, just because it doesn't come up that often in the federal statute. But I think most of the cases, even on the state level, do, in defining kidnapping, look at whether it was essentially only conduct inherent in another offense or closely linked to another offense, or if there was broader conduct that went much beyond what you'd expect in the other offense. And you can argue the logic of that But I think that's what the case law suggests.
Mr.
And one
Campbell?
other thing I would mention is
I'm sorry.
I'm sorry, Your Honor.
Isn't what you're really interested here for purposes of what happened in the case below, which seems to me to have been not the result intended by this kidnapping statute? Isn't what you really want a clearer durational requirement? It would focus on that, interpreting the holding and detaining language to mean a substantial duration of time. Wouldn't that address the main concern you have here? Do we really need to go further to look at and whether something was inherent or incidental to, why do we need to go beyond just looking at the fact that the duration here? I think there may be a general view that in this instance, it was way too short, not nearly what the federal and local District of Columbia 1930s era statutes on kidnapping were intended to require. Why do we need to get caught? I guess I'm asking, can we stop there? And if you think we really need to look at incidental to and inherency, how do we get there from a statutory interpretation point of view?
Well, I think you're entirely right, Your Honor, that you don't need to apply Barry to determine that my client was wrongfully convicted. We have suggested Barry because there's a lot of case law that seems consistent with that. But you could just, especially for the purpose of this case, look at simply the duration, which is actually the first Barry factor. But that would not be an unreasonable way to look at the statute, that there must be a prolonged. I think that amicus has pushed that more than perhaps we have.
If you're going to look at the duration requirement, I'm sorry, I don't know why these things come from all over the place, but why does the word substantial get you where you're going, as opposed to, like, amicus uses the word and includes it in their suggested instruction, lengthy period? Is substantial more or less than that, or is it just the kind of word you think jurors are used to dealing with, or we have some experience knowing that they know how to deal with?
A lengthy period would be, under either test, I think my client was not properly convicted. If the court wants to adopt the lengthy period as the interpretation of the statute, which is what amicus advocates, that.
But do you
seems to me
think
to be
it's a
perfectly
tenable interpretation of the statute?
I'm sorry, Your Honor?
Do you think it's a viable or a correct interpretation of the statute?
I do, Your Honor. I guess we use the word substantial because it's got support in the model penal code, and it maybe is linked closer to the text of the statute.
I guess that's what I'm trying to get at. Why? Why is it closer? Because it's mushier, or?
One of the things we looked at and one of the things we relied on, and this court has relied on in other contexts, even though it hasn't been adopted in this jurisdiction, is the model penal code commentary, the model penal code definitions. And to us, substantial seems a reasonable way to interpret the statute. Of course, you've got to get the definition of substantial. And in our view, it makes sense to interpret the statute, interpret substantial, consistent with the Barry factors. But
can I just make sure I understand what that means? Do you mean then that rather than just being a numerical inquiry, like who knows what the number would be, maybe this court would pick a number and say it, or maybe juries wouldn't be told and they'd make their own judgments within a range of reasonableness. But one approach is it's just a period of time, and you just have to figure out, is it substantial or not?
Right.
And that would be some number. Another would be, and this is to use a phrase I think that Judge Steele used in a question, that the inquiry is not so much the substantiality of the duration. It's the substantiality of the infringement on liberty during the period of the charged offense, which would then factor in. So the answer might, the answer might vary. It's not like the real number is, an hour. It depends, and it depends on what's going on during the relevant time frame. do you have in mind that if we were going to adopt a requirement that that there be a substantial detention, that it would be communicated to the jury as just a durational idea? It's like it has to be long enough to be substantial. Or do you have in mind what it sounds like you're saying is that you'd say to a jury, you got to figure out whether this was substantial. And in figuring that out, you got to take into account a bunch of things about what's going on. Did it increase risk? Barry lists some of those factors. Other states have a variety of other ones. Was there movement? Was there some separate reason the defendant had for committing the offense? So it could be lots of different things. Did it increase risk to the victim? Did it? Some of it was it for a more serious crime? Some of them treat as making it more likely to be kidnapping, that it was used in order to facilitate a crime, which is part of what the DC proposed statute does. Which of those two things, though, do you have in mind? Just a number that's really only about duration, or something that's really wrapping in all of the very factors?
To be clear, we don't have any, that's one way the court could go, is to adopt a number. And I think any number that's adopted would result in my client not being convicted. But to my mind, I think it makes more sense to have, as I think what you're suggesting, Judge McLeese, is a multi-factor test. I mean, if you have a very.
But the point is, it's not solely durational in the sense, it's a multi-factor test about substantiality more broadly understood.
In my mind, that would be the better way to go.
Why is that helpful? Right, that over here, sorry. So, last night my daughter went to soccer practice and they had a scrimmage and she was trying to score and she got tackled by two players who came at her in a pincer movement, who detained her on the pitch, who actually moved her because she fell. And she was slightly injured. She's got some skinned knees. If you look under this multi-factor, substantiality of infringement on somebody's liberty interest, did the two girls who tackled her kidnap my kid last night? That seems a possible result of that test, and no less absurd than the result in this case.
Well, I don't know. Again, it depends on exactly what factors you would tell the jury that they needed.
I was just looking at the factors that Judge McLeese just listed, right? I mean, if we're talking about, interruption of moving someone, having the intent to have some benefit, right? The benefit was they didn't want her to score, right? So they impeded her movement. They escorted her some distance. She encountered some danger and in fact some injury, right? All of these things that I thought were kind of in the mix happened, but I don't think anyone would call that a kidnap.
I think one of the things you can incorporate into the definition of substantial is sort of the nature of the definition. Was she just effectively detained for a few moments on a soccer field? Or you could have a very short detention where someone was reasonably put in fear of their life. And, that factor might make it a more substantial definition, a more substantial detention. So
I'm sorry, I'm missing you because I thought we were going for clarity here. And this all seems super mushy. And I mean, add in the extra fact that, my child is of my size and these two people on the field were much bigger than her. It's a little intimidating being out on the field, being tackled by two people. I mean, there might have been fear. So throw that in there too. I'm not seeing how this is helpful in clarifying what the crime of kidnapping is.
One of the problems with this statute is, and I think Judge Deal discussed this a bit in his concurrence, is where do you draw the line? I mean, that's what we're discussing here. Where do you draw the line? What is and what is not kidnapping? And that's a very difficult thing to do. I guess, the point I would make, and I think Judge Deal made it, is that we essentially have drawn a line. And
counsel, why are we focused so much on the word kidnapping? I mean, I realize it's the title of the statute, but it's only one of the ways to violate it. And yes, if you walk down the street and you ask someone, was this a kidnapping? Probably the vast majority would say no. And when you talk about a 30-year maximum sentence, seems out of whack. But the statute also covers seizing and holding. Seems like there's a strong argument that that's what your client did here. He seized someone and he held them. Again, how long to hold, I don't know. But the statute also allows for a very, very minimal sentence too. So how do we know that the legislature didn't mean to cover things all the way from minute seizing and holding with a very short sentence, all the way up to major kidnappings and long detentions, major sentence? Why is that not a reasonable reading of this statute?
Well, for one thing, if you look at the legislative history, I think it's clear what Congress had in mind. And they had in mind conduct that was in some way comparable to the widespread kidnapping that was going on.
Are you talking
in
about the
nation.
legislative history in 1933?
I'm sorry?
Are you talking about the legislative history in 1933? Well, I mean, I think that that's quite true. But at that time, the statute that Congress enacted would have only covered that kind of conduct because there was a requirement that the seizure, holding, detention, et cetera, be for the purpose of obtaining ransom or money. To my mind, the question is, okay, but what about the statute that Congress enacted in 1965? Because that's when Congress took out that requirement that did make it, limit the offense to really what we think of as classical kidnapping. They then took out that requirement, essentially eviscerated it by just saying or otherwise, so that there isn't a bad purpose requirement anymore. And what Congress said it was trying to do then was to make the DC statute like the federal statute, which also did not have a bad purpose requirement. But the DC statute was very different from the federal statute in two critical ways. The federal statute had two big guardrails. One was the word unlawfully that's in it. And then the other is that there was a requirement of interstate transportation. So there too, the sort of very sweeping reach of the current statute wasn't present in the federal statute. So it does seem like in 1965, Congress thought it was doing one thing. Let's make the DC statute. Let's just make a change to the DC statute. It'll make it a lot like the federal statute. But they ended up creating a statute that does, by its terms, seem like an initial reading on its terms seems quite broad. And so it seems to me the question is more, what was the intent of Congress? What was the intent of Congress in 1933 about the words hold or detain? And I tend to think they wouldn't have had to have and probably didn't have any prolonged sense then because other terms would have performed that function. And what was the intent of Congress in 1965? Well, the intent of Congress in 65 was to make it like the federal statute. That they didn't do very well because they created a statute that's a lot different and a lot broader. But it seems to me that the question is not how serious did Congress view the offense in 1933, because it made a big change to it in 1965. The question is, what was Congress doing in 65? Or at least to me, that seems like the more germane question. That's the statute. There are minor changes since then, but pretty much that's the statute we're interpreting is the one Congress created in 65.
That's true, Your Honor, but the legislative history for the 65 amendments indicates that Congress was trying to bring the statute in conformity with the federal statute. In the federal statute,
that's a slight overstatement. They said they wanted to make it more like the federal statute. I'm not sure they said they wanted to bring it into complete conformity, but I take the thrust of your point.
Right, and the federal statute was amended to broaden the purpose requirement, essentially broaden it into infinity. I believe that was in 1934. So that was around the same time as the original statute was enacted, but maybe more fundamentally, the only thing that was changed in 65 was the purpose requirement. The definition of kidnapping stayed the same. So
well, I'm not quite sure what you mean by that. And this gets back to Judge Shanker's point, I guess, but the title of the chapter that this is found in is called kidnapping. The title of the offense actually isn't that, it just says definition and penalty. This is not this statute by its terms is not merely a kidnapping statute. You'd agree with that. Kidnapping is one of the list of 9 verbs that compose part of the first portion of the statute. So it's got to be more than kidnapping.
I agree with that.
Define kidnapping.
It's not necessarily limited to what was traditionally thought of as literally a kidnapping. I think Congress wanted to be broader than that, but I think it's also equally clear that Congress did not want to cover conduct like what happened here, which is a momentary grabbing of one person by another.
That's my question. How do we know that, given that Congress allowed for a 0 sentence, all the way from 0 to 30? So maybe it meant to cover a broad range of conduct, seizing and holding for a very, very short period of time, low sentence, kidnapping and holding for a long period of time, 30 years, and everything in between.
Well, in this case, for example, my client was convicted of a sexual touching. But that really has nothing to do with the kidnapping offense. If my client had,
Well, counsel, your colleagues on the other side at page 13 of their brief include a legislative history report from the congressional record that talks about that amendment was also to expand the motivations to lust, revenge, desire to end loneliness or something of that nature. How is that not about that? And how would you answer Judge Shanker's question with that included?
well, the point I was going to make was that if instead of a sexual touching, if my client had walked up behind ER and grabbed her on the shoulder because he was kind of rude and wanted to talk to her, hey, I want to meet you. That, under the government's definition, would be a kidnapping. One person.
It wouldn't necessarily be a kidnapping. It would be a seizing and a holding, right? I mean,
Because it wouldn't be a seizing or holding.
why isn't that a seizing and a holding? Maybe warrants a very, very low sentence, but why isn't that a seizing and a holding? We don't have to call it a kidnapping.
Well, I think in the government's view, it is a seizing and holding, and it merits a sentence that the judge can impose. In this case, it was 5 years up to 30 years. I don't think that's a reasonable interpretation of Congress's intent. Judge Deal gave us an example of someone drops their wallet and then the person comes up behind them and grabs them and says, hey, you dropped your wallet. That, under the government's definition, is a kidnapping. And I think that's a totally unreasonable
Or a
interpretation
seizing
of
and a
statute.
holding that's a class A felony. And if the person happens to have a heart attack at the time that they're seized, then, you could say that's felony murder right there.
Right, I think that's correct. And that's just not a rational interpretation of the statute.
That's why, I take one thrust of your point is that some of the hypotheticals are entirely innocent conduct. And I do think myself that it's a pretty obvious absurdity in the statute that when Congress in 1965 removed the bad purposes and put in or otherwise, meaning any purpose benign will do, apparently, it created a statute that by its terms can apply to conduct that does not seem to be wrongful at all. It's not wrongful in any way. And it seems like Congress wasn't intending to do that because they said we're trying to make it a lot like the federal statute, which has an unlawfulness requirement in it. So if we take it as, if we assume that that aspect of the statute is absurd and that it might call for fixing one way or another, that is related to, but not exactly the same as the question of duration, because your client was found to have engaged in what at least arguably was a seizing and a holding or detaining for not a good purpose. So your case doesn't really involve scenarios of non-wrongful conduct, these fleeting and non-wrongful seizures. So I wonder how much it helps your client's position or how germane it is to the issue we most directly have in front of us, that it may well be true that the statute is absurd in lacking a wrongfulness requirement, and that might need to be fixed in an appropriate case, of which this isn't directly one. So I'm just curious what your thoughts are about that set of topics.
Well, my client did do so. He was convicted of doing something that was wrongful, and the council has created a statutory scheme and for sexual offenses, and he was convicted under that scheme. But that was not why the jury wasn't told that was in any way a factor in determining whether he had committed the crime of kidnapping or not. And my understanding of the government's argument is that that's totally his purpose was, as long as a purpose to do something that would benefit him, the purpose is totally irrelevant. One point I wanted to make is sort of about the definition, the structure of the statute. I mean, the statute has this very strange two-pronged structure where you have a list of verbs and then you have a requirement for a holding or a detaining. And, under the government's very broad interpretation of the statute, you could simply eliminate the first prong. The first prong does no work. You've got a holding and detaining.
I'm puzzled by that. And I just want to make sure I understand. This is your superfluity argument, and I want to make sure I understand it. So there are 9 verbs or gerunds or whatever they are in the first component of the statute. And then there are the 2 hold or detain or with intent to hold or detain in the second tier of the statute or part of the statute. Is it your view that hold or detain, those words, have to add something to all 9 of the items on the first list?
I mean, I think that's the way it's written.
So what do hold or detain add to kidnap?
I'm sorry.
On your view, one of the items on the list of 9 is kidnap.
Right.
And in your view, on any view of hold or detain, what do they add to kidnap?
Well, that's sort of my point, Your Honor, is that in our view, that sort of overlapping dual structure, the fact that they added that first section with all these verbs.
No, I'm just saying on your interpretation. Take, hold, and detain and interpret as you would like to. What does it add to the word kidnapping? What do either of those terms add to the concept of kidnapping, which is one of the 9?
Sort of a matter of the dictionary definition of logic, it doesn't add anything. I think.
Which leads me to wonder, then why do you think we should be construing the statute to think that hold or detain need to add something to seize? If we know they don't add anything to the word kidnap, then why do we need to think that, well, but of course they must add something to seize? Well, I just don't see the chain of reasoning unless you think they add something to kidnapping.
Well, I think there's the general rule is that you've got a clause in a statute and you don't ignore it. You don't ignore language in a statute.
Well, I get that, but and that's another half of it, right? Because you were saying you think it needs to add to every one of the 9, but they aren't superfluous if they add to at least some of the 9. And I would take it you would agree they add to words like inveigle or entice. You can inveigle someone without seizing, holding, or detaining them, and you can entice them without holding, seizing, or holding or detaining them. So they add to at least some of the items on the list. Would you agree?
If you're looking at the dictionary definitions, yeah. But Judge Moncrief, the broader point I think we're making is that a court, it's very almost impossible to distinguish many of the terms in the first prong from the terms in the second prong, and that's one of the reasons why the statute is ambiguous. Why did Congress do that? In our view, one of the reasons Congress did that is that to suggest that a holding and detaining, just a holding detaining is not sufficient, that there's got to be something more, something significant, something substantial.
And why do you, I mean, it seems like a different way of looking at it is Congress had a kind of a kitchen sink list of 9 that are largely overlap. I mean, I don't know what the difference between inveigling and enticing is. Someone may shed light on that today, but I'm very puzzled about what it might be. So it's like a kitchen list of 9.
Mhm.
And then there's a set of, you got to hold or detain, which adds to some of that, you know, which is a requirement that has a function in the statute as it's written, because it adds to some of those 9, if not all of them. And then, of course, at the time Congress wrote those words, there was a purpose requirement that would naturally have meant that, you know, none of these words could have really been applied to petty conduct. And then in 65, Congress takes out the purpose requirement that means, oh, wow, if we give those terms the meaning that they normally would be given, you end up with a statute that seems to have, you know, harshly punish either innocent conduct or relatively minor conduct. I'm not sure why any of that leads to an inference that in 33 or in 33, 32 or 65, Congress thought hold or detain had a long temporal duration.
I think the fact that the first prong is there suggests that Congress did not want the courts to look at just holding and anything that conceivably a holding, anything that could conceivably be a detaining. Congress did not see that as a kidnapping. I think those 2 prongs together suggest that Congress meant something more than that. And admittedly, it's hard to, from the text itself, it's hard to understand exactly what Congress meant, but I think it's a reasonable inference that it wasn't just holding and detaining. And that's why, in our view, this court should look to other tools, including perhaps most significantly the relevant case law, and also the absurdities that would result if what the government is advocating were adopted.
Mr. Kaplan, I think you indicated you wanted to reserve a little time
Yes.
for rebuttal. I don't know if there are any other questions from my colleagues for you at this time. If not, you can reserve your 5 minutes or so for rebuttal.
Thank you, Your Honor.
Good morning.
Good morning. May it please the court. Stephanie Schneider on behalf of Amicus Curiae Public Defender Service. I'd like to reserve 2 minutes for rebuttal. The holding or detaining element requires the defendant to maintain physical control over the victim for a lengthy period in a manner that isolates the victim from aid and goes beyond conduct incidental to another offense. This
Schneider,
construction.
Can I ask where you got that definition from? That lengthy period of time, isolated. I think if we didn't have the text of our current statute, that makes sense. And that definition would help clarify why the facts in this particular case seem absurd to call kidnapping. My struggle is where you read that from the language that we've just been talking about in our current statute and how we get to that view.
Sure. So we're getting that from a combination of the text, the structure and history of the statute, including contemporaneous definitions of hold and detain, the statute's two-part structure, the severe statutory penalty, Congress's background understanding of a kidnapping when it passed the statute, the historical context and legislative purpose, and authority interpreting the analogous federal statute. And I'll take each one in turn.
So you'd start from the premise that the statute as written is vague or absurd or both?
I think I start from the premise it's not a model of clarity, but I think when you sort of study the structure and words in it, they all support our interpretation, but our interpretation is guided by looking at the historical context and the legislative history as well. But I do think the text is doing some of the work there. And I think the structure is significant. So I would agree that holding and detaining, were common words in 1933, susceptible of many different definitions, but principles of statutory interpretation tell us we have to construe those ordinary terms, which have many meanings, in the context of the statute of a whole. And we need to give them meaning beyond the conduct that's covered in the first element. So as we read the statute, the first element is describing all manner of gaining physical control over the victim.
Can I ask you, why do you say that? It doesn't seem to me obvious that inveigling requires physical control. So if somebody goes on the internet and says, I've got something really good to sell you, come to such and such a place and such a time and I will sell it to you. And then, the person, the recipient of the email or whatever, text or whatever it is, looks at that and says, oh, the great idea, I'm going to go to that place. Well, that person has been inveigled. But the writer of the email might not even be there, or there's no physical control. So I don't really see why enticing or inveigling contemplate physical control. So I'm a little puzzled by that first step in your thinking.
So I think the way we are viewing it is it's a means of bringing, right? So we've got physical force, we've got deception. Inveigling, enticing, and decoying are all ways of bringing the victim to the defendant, for the purpose of gaining physical.
Well, I get that, but I just want to make sure.
Yes.
So it's not. But is it a requirement to have inveigled somebody? Do you actually have to have gotten physical control over them? Is that a component of inveigling, or is your point that I think it's right that these are means directed at gaining physical control, if that's what you're saying. But to say that they require actual physical control seems to me not obvious.
So, if we look at the 1933 definition in the Oxford English Dictionary, the definition of inveigle is to gain over or take captive by delightful allurement, to entice, allure, or seduce. So there is a definition of inveigle that does encompass that notion of, it does encompass that notion of gaining over or taking captive, but
just to make clear, so and that's a fair enough point. So it sounds like you think in the hypothetical I gave, there isn't inveigling yet, and there's only inveigling if the person who has made the false claim about what will be there comes and gains physical control. That's the moment. The inveigling, for purposes of this provision, occurs at the moment of physical control. Before then, it's attempted inveigling.
I think it may qualify as like that's the purpose and that's the end, to which it's going. I think maybe that sort of the end, the purpose of taking control is part of it. I think
I'm just not sure what your answer is to my exact question, which is, in your view, in your understanding of how the statute works, does inveigling for that requirement for that option, A, whichever one it is, D, of the list of the first tier of requirements, or does that require actual physical control or not?
I think it is. I think it does require the sort of that deceit for the purpose and really probably the achieving of the taking control. Like we view these first 9 verbs as ways of taking control. And we think what Congress was trying to do.
Enticing. So you have the stranger who drives up in a van and offers the kid candy. The candy is quite enticing, right? But there's no taking of physical custody until the stranger grabs the child. And at that point, we're into the hold and detain portion of the statute, aren't we?
Yeah, I mean, I do think the real work in the statute, and we'll talk about it, is being done by the hold and detain. And what Congress was trying to do is it recognized that there was this national epidemic of kidnapping, and it was being accomplished through a variety of different means. And so it's trying to capture sort of all the modalities, by which kidnapping, was occurring. But then it has this second element, right? This holding and detaining, which is really what the heart of the offense of kidnapping is. And that holding and detaining, it has to mean more than the first 9 verbs. And it's also consistent with sort of the common
Does it
law.
have to mean more than all 9 of the first 9 verbs?
It has to be, yeah, I think it does. And I think it is adding more. And
what does
I
it add
heard
to kidnapping? And what would it add to kidnapping?
yeah, so I think, well, you're sort of looking at those dictionary definitions, not kidnapping perhaps as the offense, but just sort of as sort of defined in 1933, it was defined as to steal a child to carry off a person by illegal force. So if you look at it that way, it is adding to that definition. Now we think
Can you
kidnapping.
slow down because I'm not quite sure how.
Sure. Well, if you look at kidnap sort of as a term as defined in the dictionary, it was to steal. This is in the Oxford English Dictionary. It was defined as to steal a child to carry off a person
And
by.
how could you do those things without holding or detaining the child?
Well, I think we understand holding or detaining because it has to be more than that. I mean, that is lending support to our argument that holding has to be lengthy. It has to be prolonged.
So your point is, it seems a little cross-cutting to some of the other points, but is it the idea is that kidnapping might have been understood to be transitory. And so it was important to use words like hold or detain to communicate that kidnapping couldn't extend to transitory things. That seems very contrary to other of your lines of thinking.
I don't think kidnapping as an offense was understood to be transitory. I'm saying that when they use these 9 clearly overlapping verbs, it was sort of a belt and suspender approach to try to capture the different modalities, the different ways that kidnapping was being accomplished during this epidemic of kidnapping, where it was all manner of ways. There was the grab, people were being grabbed on the street, but it was also, there was a lot of, luring the doctor, on the pretense of a house call and then taking him for days. I think Congress is trying to get at all the different ways it's accomplished, it's initiated, accomplished in that first element. But the heart of kidnapping has always been the heart of the offense at common law. And today in the statute is that second element, that holding or detaining. And our argument is it has to mean more than the first element. And we think that understanding it to be a lengthy isolation from aid comports with the background common law understanding that is the heart of kidnapping.
So what happens when the stranger in the van, gives the kid a lollipop, seizes him, puts him in the van, turns out the van's out of gas. So he has to let the child go. In your view, that's not kidnapping. That would just be attempted kidnapping.
So that
the child was seized and detained for some time.
So under the statute, there has to be a holding or detaining, or it has to be with the intent to hold or detain. So the question, I think, in that instance would be whether the prosecution could show that there was that intent to have sort of a lengthy, lengthy isolation made. And they may well be able to show that, right? It may be that there have been preparations that are made for that lengthy holding. There may be text messages.
What is minimally lengthy?
So we understand lengthy to be in the realm of hours, not minutes. Really, because of the statute's 2-part structure, the severe penalty that was originally life imprisonment, now 30 years, and this background concept of a true kidnapping against which Congress was legislating, holding or detaining has to be understood as akin to keeping a victim prisoner.
Can I ask you, with respect to all the points you're making, like with respect to any current statute around the country or any current case law around the country, or kind of treatises saying what kidnapping was back in the day, or any materials you have, or dictionary definitions, any of it, would any of them support the use of the word lengthy or prolonged or protracted, or like where would you find somebody like a treatise that says, oh yeah, kidnapping requires protracted, or any statute that now, or any case law that generally requires protracted? Where would you find?
Sure. So if you look at the commentaries to the Model Penal Code, for example, that have traced sort of the evolution of kidnapping in the common law background, one of the points they make is that the crux of kidnapping has always been sort of prolonged isolation.
So that's the Model Penal Code's word is prolonged.
Yes, it's been sort of,
I mean, the model penal code settles on the word substantial, which is, somewhat different, but.
it is, no, I'm talking about the commentaries when they're they talk about what the crux of the offense is, what kidnapping is getting at. And the point that they make based on, lots of scholarly review is that originally that was accomplished via asportation. So at common law, kidnapping required taking the victim out of the jurisdiction. And that was the true harm of it. And the reason that was harmful is because that, effectively cut the victim off from aid. It invited prolonged detention, which is what they say, and it invited violence, right? And that was sort of the heart of the offense. And then
here's
legislature.
One thing that puzzles me about that is, I get the line of thought. I think it is true that the heart of the common law offense was asportation. You're not suggesting we read that requirement in, but instead you're suggesting we should read in, because that was taken out, sort of intentionally. You're suggesting we should read in the consequences of the asportation was the heart, although that heart has been removed. That seems a little puzzling.
So I'm not saying that asportation was the heart. I think the point that the model penal code, scholars are making is the heart was the lengthy isolation from aid, and asportation accomplished that. What sort of legislatures recognize kind of turn of the century in the 1930s is that same harm, that lengthy isolation from aid could be accomplished without removing the victim from the jurisdiction. So they wanted to punish that same harm. And the way they did that is by replacing an asportation requirement with a holding or detaining requirement. So it's not just that they are taking asportation out, they are replacing it with a second element, a holding or detaining. And what we are arguing is that element is getting at that same harm, but it's getting at that harm when it happens entirely within the district.
Can I ask why isolation from aid? I just want to probe what work that's doing in your view. Can you not do an open air kidnapping? Hold somebody at gunpoint. We're going to walk to every ATM within a 5-mile radius. We're going to be doing this all day, and we're going to empty as much money out of your account as possible. It doesn't strike me as isolation from aid. Do you think it is?
I think it is, like, it's in a sense, it's sort of constructively isolated by, the fact that you've got the gun to your head and nobody can help you. I think that is, I think in the hypothetical Judge Easterly gave earlier about, the soccer game, that strikes me as not isolation from aid at all. So I do think it's doing work.
Do you think when we look at your word lengthy and prolonged, does that do more or different work than the use of the word substantial duration? And if so, can you explain how? And I guess I'm going to add in another part to my question is, I had understood that you were favored perhaps a hardline amount of time that we should actually read in, as opposed to just words like lengthy, prolonged, or substantial duration.
Yeah, so we've asked for lengthy. We think that is a more clear word than substantial. We think that substantial sometimes is understood to be a lot. Sometimes it's understood to be a little. We think lengthy just adds more clarity. I think our understanding of what lengthy is getting at, is something in the realm of hours, not minutes. We have not asked the court to pick a bright line number because it feels like that is sort of hard to do on the statute. But we know that Congress is not getting at a holding for minutes, and we know that for a couple of ways. We know that based on the legislative history, the severe penalty. One of the things Chatwin really emphasizes is that the statute, the analogous federal statute, it has to be construed narrowly in light of the historical context and the purpose it was trying to solve, which was this epidemic of highly organized kidnappings. And that's why it has this very severe penalty.
Yeah, at the time, it was a lifetime offense, and they contemplated making it eligible for the death penalty. And I think this goes to one of Judge Schenker's questions earlier. Do you know in 1933 if mandatory minimums were even a concept that was legislated? Do you think, were there any congressional acts that had a mandatory minimum in it?
I don't know the answer to that question. But one thing I think that Chatwin did emphasize is that the maximum penalty is what it was looking at, in terms of the severity of the offense and the concern about overreach and absurdity. When it talks about, the potential for the boundaries of potential liability to be lost in infinity, it is very much wrapped up in how severe this penalty is and how if you, divorce a reading of the statute from its purpose and historical context, you could end up with I mean, precisely what happened here, a very absurd result.
One other question. In response to some of the hypotheticals, like surprising a friend with a hug, one thing the government says is, well, that wouldn't be a kidnapping because it would presumably be consented to. Do you understand consent to be a defense to kidnapping? I mean, there are all sorts of crimes you can't consent to. I can't consent to my own murder, is my understanding. I don't think I can consent to a variety of other types of offenses. And I don't see anything in the statute that suggests it's a defense. Do you think it is?
I mean, I don't see it as an affirmative defense. I know it has to be involuntary. So I guess, we could talk, there's a question about what that means, but I think it's
Why do you say that?
because I think Chatwin says that. I think I'm taking that from Chatwin.
I just don't see it in the,
Oh.
I mean, why can't I say, there are the things called escape rooms, right?
Mhm.
And they seize you. Maybe they also entice you through false advertisements about how fun it is. And they don't let you out until you solve the puzzle, and then they hold and detain you. I don't see why that's not a kidnapping.
So, I mean, I think that
Under the government's reading of the
let's-
statute. I'm also not sure why it's not a kidnapping under yours. So, you can answer either one.
Sure. I mean, I think the government, as I understand the government's position to be that they seem to think that any sort of splits, a split second is enough. So yes, I am concerned that under their interpretation, that would be a kidnapping. I think under our interpretation, there's a couple of pieces you look at, right? One is you look at, is it lengthy? And two, you look at isolation from aid. So, I mean, are they isolated from aid, or is it, they're trying to have you there, but you can, pick up your cell phone, call someone, say, I don't want to do this anymore. I mean, I think maybe you're envisioning that you call your cell phone and you say, I want to leave, and they won't let you. I mean,
I guess that's a way that consent could factor in. You could say, well, you're not isolated from aid if you're free to remove your consent from the detention. Is that roughly your answer?
Yeah, I think that's right. And I think, we got it via isolation from aid, but I guess consent is, is another way to think about it. But yes, we've thought that, you're not true. You may not be isolated from aid if you can just change the circumstance by saying, no, thank you, I don't want to do this, right? I can pick up my cell phone, I can open the door. I mean, then you're not actually isolated from aid. And so it is a piece. It's more than just duration. I think isolation from aid, is a piece of it, and it is doing work in addition to the duration.
Can I ask
And that's
you-
why we have pushed both.
Back on duration, with respect to your argument that we should read in terms like lengthy or protracted or prolonged, is there any jurisdiction that has a modern kidnapping statute, either by interpreting one that has sort of more general language or some that are very detailed? Do any of them have that as a general requirement for kidnapping, even for aggravated kidnapping?
So you're talking about like a numerical length, is that?
Or any word like prolonged?
So a lot of them, I think a lot of them were based on model penal code and use words like substantial, but that has, I think, ultimately posed problems for courts. You find that you end up with model penal code jurisdictions that end up resorting to the Berry factors because they're still struggling with these very questions. So you see that in New Jersey, you see that in Connecticut. So it hasn't entirely solved the problem they were attempting to
Again,
solve.
to try to nail down and answer the question, are you aware of any statute, any modern or past kidnapping statute that ever had as an express general requirement for kidnapping that there be a lengthy, prolonged, or protracted detention?
I don't know off the top of my head specific, if they've used that specific language.
And second, relatedly, with respect to isolation from aid, are you aware of any statute, past, present, that has as a requirement for kidnapping that the victim of the kidnapping be isolated from aid?
I believe New Jersey talks about isolation from aid, but I have
That's a factor for sure in a number of statutes, but as a requirement for something to be a
like
kidnapping.
in the text itself. I guess your question is in the text itself of the
Or in
statute.
any case law interpreting the statute.
Yeah, I think New Jersey in particular comes to mind as really emphasizing the significance of that isolation from aid, as part of it. And it's escaping me exactly how it comes up in the text versus in the case law, but they have really emphasized that is part of kidnapping. So I think the answer to that is
I know we peppered you with questions and taken you over your time. I don't know if any of my colleagues have any additional questions.
Just one additional question, if the chief is okay. So earlier in response to Judge McLeese, you said that the best evidence for a durational requirement comes from the model penal code, but the commentary to the modern penal code says that they were trying to eliminate an absurdity, right? That was with sort of asportation within your own house or durational requirements. And so I guess I'm wondering, how is it the fact that the model penal code was sort of critically aware that older statutes did not have a kind of lengthy component to it, evidence that in 1933 or 1965, we understood hold and detain to have kind of time limits.
So I think what I was trying to say is that the best evidence for isolation from aid and the significance of that core principle is coming from the model penal code. And they do talk about how asportation invited prolonged, detention and isolation from aid. I mean, in terms of duration, I think some of the best evidence, frankly, is coming from the two-part structure and the fact that holding or detaining has to be doing work above and beyond the verbs in the first statute. And I also think, additionally, just that background context of what was Congress envisioning when it was talking about a kidnapping. It really was thinking about what Chatwin described as sort of a true kidnapping, these sort of organized, lengthy kidnappings. It was not thinking that there was a problem with assault or sexual assault or robbery that needed to be solved. It had this much broader conception. So I think those are really where we're getting duration from.
I apologize for asking one more question, but it wraps back around to a question that Judge Shanker had that I'm interested in your response to. When you say, well, Congress must have had in mind true kidnappings, it gets me thinking of the question that Judge Shanker asked, which is kidnapping is one of the list of nine things that are the first part of the statute. And it seems odd to say that Congress must have meant to limit the statute enacted to classical kidnapping when kidnapping is like 1/9 of one part of the statute. It seems like collapsing the entire meaning of the statute into one of its terms. So you have a response, to that problem?
Yeah, I mean, the term true kidnapping is coming from the Supreme Court in Chatwin, so it's not a term that we're making up. But what I think Chatwin is trying to get at is that the statute has to be construed narrowly in light of its, sort of that historical concept and conception. I take your point. I think it's odd that they use the word kidnapping in a kidnapping statute. I mean, we certainly acknowledge that this statute is not a model of clarity, but the way that we understand that in its historical context is that what Congress was trying to do is it recognized there's this national epidemic of kidnapping. It's all of which were kind of lengthy and isolating. I mean, that is the problem they were trying to solve. But what they recognize is it's being effectuated in all different, new and creative ways via organized crime. And what they really want to make sure is that even though it could be committed different ways, they were going to capture it. But at the end of the day, that holding or detaining is a second layered on element. And it's doing work.
Decided that instead of passing 9 different statutes, we're going to pass one statute that uses all of the terms and provides for a broad range of punishment depending on how severe the crime is. Why do we know why do we think that that's absurd?
So I think the Supreme Court says that in Chatwin, right? The Supreme Court looks at the severe penalty and says it is a reason to construe the statute narrowly in light of its historical context and history. And so the Supreme Court says that. And I think it's correct. I mean, this is not what Congress was trying to capture. And the absurdity comes in now, right, where you have a bear hug being punished as one of the most serious felonies. I mean, they were very concerned that the boundaries of potential liability would be lost in infinity. That was, something they said, we can't, construe the language loosely. We've got to construe it narrowly. And I think their fear has come true in this case. And we, the District of Columbia, are an outlier. Nobody else is construing the federal statute like this as analogous language. And among the states, we are an outlier in construing a kidnapping statute to encompass a split-second grab.
All right, Ms. Schneider, thank you. We'll restore some of your time for rebuttal.
Thank you.
So, good morning. My name is Nick Coleman, and I represent the United States.
All right, good morning, Mr. Coleman.
Appellant and amicus are essentially asking this court to graft on two new
May I ask you
elements.
to-
Yes, sure.
I don't know if the mic comes a little closer.
Okay,
Thank you.
sorry.
Thank you.
It's been a long time since I've argued here. Appellant and amicus are asking this court to graft on two new elements to section 22-2001. The first being a durational element of uncertain or unspecified length. And the second being a sort of non-incidental requirement that an offense under this statute cannot be incidental to some other offense. This court should decline that invitation because neither one of those proposed elements is supported by the actual text or structure of section 22-2001. It has three elements. The first of those elements, as we know, is a long list of verbs that, of course, does include seize, kidnap, and abduct, but also includes inveigle and entice, as well as kidnap itself. The second element is hold or detain, or with the intent to hold or detain. And the third element is the purpose element, which at one time was only a purpose for ransom or reward. So essentially an extortionate purpose, but is now or otherwise. And as we know from this court and the Supreme Court, that purpose can be for a non-unlawful purpose.
Well, tell me, counsel, I was a little bit confused about that. Your colleague on the other side, Mr. Kaplan, noted that it was your position that there could be for some personal benefit. And as I looked at your brief and reviewed it again, at note 17, you have in that there must be a holding or detaining with the intent to obtain reward, ransom, or other personal benefit. Is that in fact the position? And if that is your position, could we not just read back in a bad purpose requirement as Judge McLeese referenced in some of his questioning and call this a day?
So I'm not sure, again, that the purpose or otherwise is where one would get the sort of bad purpose from it. I mean, I'm just going with what the Supreme Court and this court have said, which is that the purpose does not actually have to be illegal. Again, I don't have the case right in front of me. I'm sorry, you're right.
But does it require a personal benefit?
So I think that is, I think that what the courts have said, it has to be of some benefit to the perpetrator. Yes.
You mean
in other
actual
words,
benefit or perceived benefit? I mean, I can't believe the jury really has to say, oh yeah, and as this worked out well for the defendant, the defendant got a benefit out of it.
I don't know that this, I'm not aware of a case in which that particular issue has been posed. So, and I don't think that this court needs to get hung up on that specific aspect of the statute today, whether the benefit needs to be personal benefit to someone else.
So it's not
I
obvious
think
to me
what the
it's not obvious to me there needs to be a benefit at all the way it's worded as it says.
Right. It just has to be or other.
Well, it says for ransom or reward. So for two reasons or otherwise.
Yeah.
It doesn't say or for another reason. It says like or otherwise. So
Or otherwise.
meaning or not. Right. So it seems like one way of reading it is it's not a purpose requirement of any kind. There doesn't have to be a benefit, there doesn't have to be a purpose. You could wonder whether you can get philosophical and wonder whether people do things with no purpose whatsoever, or if they always have some purpose. But it's just not obvious to me that it has any requirement left.
I think the work it does do, as far as I can tell, is to make sure that the action has to be intentional. In other words, that the detaining or holding must be actually intentional.
Why does that do that textually? It says for ransom or reward or otherwise. So if
right,
I did
but
it
it has-
inadvertently, then it's not otherwise. I don't think it does it textually, at least by its plain language is my only point.
Again, I'm not aware of any case that has tried to test that to its absolute limit.
Well, I'm just asking by language.
Right.
When you look at that, why does it require intentional action?
Right. I mean, Congress could have just.
And my question is about language. So those exact words, why do they imply in a normal reading intentional conduct?
So I think the fact that Congress didn't just strike it out entirely means it still serves some purpose, even if we might think it doesn't serve the purpose that it used to use. I think the or
Right, my question
otherwise.
is, why would you think from those words that the purpose it serves is to require intentional conduct?
All right. So I think the fact that it still says for ransom or reward. So we know that those purposes would be covered by that third element. The or otherwise obviously broadens that, but it's still a purpose of some kind.
Doesn't Chatwin, the Supreme Court case in Chatwin say, despite the broad language of the federal statute, that kidnapping only applies when there is a restraint for an appreciable period of time. How do you square Chatwin with what happened here, where we had really only an instantaneous, momentary bear hug and growth?
Well, certainly the victim, I think here perceived.
Second, I'm sorry.
Right. Well,
Let me pause it. I'm sorry.
Let me answer my
Yeah.
question.
okay. I think the victim perceived it, as did the police officer. And although it was brief, it was perceptible. And I don't think that appreciable, if, after all, if it's hard to sort of read substantial as necessarily implying some specific length, I don't know that appreciable certainly implies any particular length other than the fact that there was a holding or detaining.
But it seems to connote a temporal requirement of some kind, and seems to suggest that reading holding and detaining as including some temporal period of time that is substantial, appreciable, and perhaps lengthy and prolonged is not unreasonable in terms of reading the plain language.
So
Interpreting
I
the statute.
I think we've cited in the brief, the fact that this court, as well as other courts, have looked at the word appreciable and said it doesn't mean any particular length of time. It just has to be capable of being appreciated. I don't know how one goes from appreciable to substantial to lengthy to isolating somebody from age.
If that's the meaning of the word that you attribute to Chatwin, then Chatwin makes no sense. It says we need to distinguish what are true kidnappings by making sure the detention was for an appreciable period of time. Otherwise, all manner of offenses will become kidnappings and the offense will be lost to infinity. If what they meant by that was, well, you can perceive a touch or conduct, well, then that's meaningless. That can't be what the Supreme Court meant when they said appreciable. There are synonyms for appreciable, like significant, like substantial, that strike me as clearly what the Supreme Court meant, not perceptible. What's your reaction to that?
So I don't think Chatwin was addressing that question. It wasn't addressing at all the length of detention. It was asking the question, was
Wasn't
there
addressing the length of detention, but it was addressing the scope of the statute.
it was a,
Back up a little bit, right? And don't
Well-
make this conversation quite so formalistic. It was looking at how broadly the statute applied. And so if you interpret appreciable in the way that you would like us to, it seems like the Supreme Court actually, while it's saying words that make it seem like it cares how broadly the statute applies, didn't actually care at all.
I think it did, but it was asking a different question, Your Honor. And again, I think any Supreme Court case, although it is certainly quite authoritative, we have to ask what was the question it was answering. At the time, it was asking, was there any holding or detention at all under those facts? And what they said was where the victim was not being held against her will. In other words, it was as the court said, an immoral situation possibly, or a situation we didn't like, where somebody who may have had a limited mental capacity or been too young had been induced into celestial marriage. Was that a holding or detention within the meaning of the statute? And the court said no, because it wasn't against her will. That was the narrow question that the court was asking. That is not the question presented here.
That you would like to give to the case, but it seems like a really constricted way of reading the things that it said. Can we back up and talk about legislative history? And so we've talked a little bit about what Congress meant in 1933, and we've talked about a little bit about what they meant in 1965. And I wonder, do you have any support for the understanding that Congress thought that this crime applied to a momentary transitory grab?
I don't have anything.
Or that was a concern and they wanted to make sure that they were going to use multiple verbs and this structure of the statute to capture this scope of, we want to get everything from the momentary grab to the Lindbergh baby case.
I guess I'd have two responses, Your Honor. First of all, in terms of what's in there in the legislative history, what we've put in the brief is kind of what's there. Certainly the 1933 legislative history is quite limited.
So I take that's a no.
I don't have any legislative history, no, but I don't see appellant or amicus citing any.
Could I ask you this question?
Yes.
Did the District of Columbia have any kind of law, false imprisonment statute at that time?
So
Because I got the impression that they also had in mind the fact that there was a gap because there was no false imprisonment statute of any kind. And therefore wrote it rather broadly to fill in a gap. What was the situation there? Or is there one now for that matter?
there isn't one now. I don't believe at any time. I did discuss this a little bit in the government's brief. It doesn't appear that the district ever codified a false imprisonment statute. It was a common law offense. And Maryland, still to this day, says it still remains an uncodified common law offense as a lesser included of kidnapping. That's false imprisonment. I don't see a lot of, we found only one case from the District of Columbia's history, which I think, as Mr. Kaplan pointed out in his reply brief, occurred on the Virginia side when there was still a Virginia side, but Virginia did have a common law offense of false imprisonment.
If we use the word substantial or appreciable or whatever, suppose you have a guy who goes down the street and just grabs at random passersby and hugs them and then lets them go. Is there any crime or is that assault?
Well, it certainly would be an assault. I do think that if you held somebody for an appreciable period of time, you would fall within the literal terms of the statute. And again, to get back to Judge Easterly's question, I think the answer to what did Congress intend to do, I think, as the Supreme Court has been very clear in the years since Chatwin, if you're asking that question, you start with the text. And if the text answers the question, you don't need to go to legislative history. You certainly don't need to be going to floor statements of individual members describing the problem they wanted to address.
Sorry, the question came up of how do we look at the statute? It seems like it could be looked at in a variety of different ways, right? There are lots of words and lots of verbs in this statute. And one idea that is propounded by appellant and amicus is that you look at sort of the initial action of taking someone captive, and then you have a second action that's required of holding them captive, right? And then this third purposive requirement that actually we're not sure what that means anymore. Another way of looking at this is saying, no, it's not that formal. We're just looking at any kind of seizure, and then you've got a wide range of penalty. And I'm trying to see if there's any support in the history for the latter interpretation of this language.
I'm not sure. So in terms of any support in history, I mean, this court has already said that it is quite clear under the plain terms of the statute that there is no requirement.
Say we were second guessing that determination.
And I understand that's why we're here.
That's why we're here. So now we're looking back to see, because there's a lot in the history to talk about why the federal kidnapping statute and then the DC kidnapping, or not quite under the kidnapping chapter, this offense, right? Why it came into being, right? We have quite a bit of information about why it came into being. We were very concerned in Supreme Court talks in Chatwin about, these bands of kidnappers who were crossing state lines, right? So we have all of that information, and it seems like on the other side of the coin, to support some interpretation of this statute, this arguably ambiguous statute, to say, no, it was meant to punish by up to 30 years as a Class A felony any de minimis seizure for no particular bad purpose at all. And we were just going to leave it to juries and judges and prosecutors to figure it out. And I'm trying to figure out if there's any support in the history or the legislative history for that interpretation.
So I think the support you can find is this. If what we thought was Congress, what Congress was trying to do in 1933 was simply to punish situations like the Lindbergh baby kidnapping, what they could have just done was just say kidnapping that involves asportation across state lines shall be punishable. That would have been perfectly understandable to everybody. It would have filled the gap that they knew existed in federal law.
There was no, I thought you said they could have made it require asportation across state lines, which wouldn't cover Lindbergh's. Maybe I misheard you. What's the simple thing they could have done?
So if what they wanted to do was simply to create a federal crime of kidnapping, which I believe was the gap that, if that was the only gap that they were trying to fill with this statute, they could have easily drafted a statute that said it shall be a crime under federal law to commit a kidnapping, and then you would have included a jurisdictional requirement like asportation across state lines. That isn't the statute that they wrote. They wrote a much broader statute than that. And what Congress did in 1965 in broadening the purpose beyond mere extortionate purposes has to be taken into account as well. We have the text of the statute, and one can always think about sort of what might be better ways to draft that statute. Certainly the model penal code tried to correct.
I feel like you're just begging the question a lot. The question is, does hold or detain mean what you say it means? You think it means all manner of grabs, right? I asked this last time. I assume your answer hasn't changed. If on the way out of the courtroom, you grab Mr. Kaplan to turn him around and say, good job, enough to break his stride in a way he doesn't consent to, you'd have to say that's kidnapping, right?
You would ask, certainly, is there a seizure? In that case, that would be that particular verb. Then did I hold or detain him, and was it for a purpose? I think the fact that one could come up with sort of hypotheticals under which what looks like innocent conduct doesn't become. I don't know that any of
just like an answer to the question.
Okay.
Is that a kidnapping under this statute? I mean, is it a crime under this statute if we don't want to call it kidnapping?
Literally, yes, it is.
Okay.
And that is the statute
just to
Congress
be clear,
gave us.
my daughter got kidnapped last night too.
Okay, well, that I think is a little different because there is this problem of implied, I think, consent.
You didn't
That's
consent to
why,
it.
well, no, I think if you play a game, let's say a football player, for example, almost all football players understand if they have the ball, they can be tackled, in other words, seized and detained. And in fact, they can, which is both an assault. It would be an offense under 22-2001. And if you take the ball away from them, that looks like theft, right? But we all understand that under the rules of the game, everyone is consenting to that.
This was a foul.
It's a foul, but
what if it's a flagrant foul?
Leave aside soccer, which is a little more complicated, but the answer you gave to Judge Steele's hypothetical seems to me obviously absurd. I mean, that can't be the right answer.
Right.
You can't interpret the statute that way. And so here's my question that relates to that. It seems to me like one way of looking at this case is that in 65, Congress just made a fundamental mistake. It thought by deleting, to my mind, pretty much deleting a purpose requirement, it was going to just make a minor change to the statute that was going to make it like the federal statute. But that's not what read literally the change that it made does, because it turned what really was a classical kidnapping statute, though it had lots of other terms, because it required extortionate purposes. So it was a pretty narrow statute up until 65 because it required extortionate purposes. And then all of a sudden it is just these words that, are pretty broad if there's no extortionate purpose. And it doesn't have the word unlawful like the federal statute. It doesn't have an asportation kind of requirement like the federal statute. So it creates a statute that on its face just seems absurd. And you don't think it's absurd. You don't think the answer that you give to Judge Steele's hypothetical is absurd. You think Congress could have intended to make it a felony punishable by up to 30 years for, let me give you another hypothetical. Imagine this case is exactly like it is, except that Mr. Velazquez Cardozo reasonably but incorrectly, he's approaching the complaining witness from behind, and he reasonably but incorrectly believes that it's his girlfriend and that she will welcome this and this will be, his very affectionate greeting to her. Your view, kidnapping, right?
Right. So I'm not aware of any case that has actually resulted in prosecution that is similar
My
to
question
that.
is,
And
my question is that a kidnapping? Not, has it ever been prosecuted as such?
I think you do have to step back and say, would that actually ever in the real world be prosecuted?
Well,
And I think
that's
the answer is no.
I mean, that's a relevant question, but I'm just asking, is the government's position that falls within the meaning of the statute? I mean, I guess you can take the fifth on that question for sure, but
it may literally fall within the meaning of the statute, just as it may also fall within the literal meaning of an assault. That doesn't mean it would actually result in prosecution. And I think most people would say,
why is that comforting? right? That we leave it to the government to sort of figure out, they'll know it when they see it. So they'll tell us when something is a kidnapping and when it isn't.
And I think the answer is that, again, prosecutorial discretion does play a significant role
Prosecutorial
in
discretion
our.
plays a role in deciding what to charge when you know what the
That's correct.
elements of the crime are. But if we don't really know what the elements are, or you're saying that this is just so broad as to encompass what are obviously absurd examples, but we can trust the government to carve that out and make sure that we don't get into absurd territory. Does prosecutorial discretion encompass that? And if so, do you have a case for that?
I think the answer is this. The elements are as they have been defined by Congress. Correction of them, if we think that Congress made a mistake or that it did something that is too broad, in the first instance is for the legislature to correct. It is not.
I'm sorry,
for-
I would like a question about the scope of prosecutorial discretion, right? Say that you agree, it is agreed that the statute as written has an absurd scope, right? Do we allow prosecutorial discretion to cure the statute, right? And we just trust that the government will know where to draw the line is and leave everything that's absurd unprosecuted and only prosecute the non-absurd? Do we rely on prosecutorial discretion in that respect? And if so, do you have a case for that?
I don't, probably because when prosecutors say we're not going to prosecute something because it's absurd, it doesn't ever reach the court.
But
So
there
I
is-
guess I
you're
don't
not
have
denying
that.
that there is an absurdity doctrine. I mean,
Right, yes.
There's a general question of statutory interpretation. I just want to make sure you're not saying what at times it seems like you're implying.
No, so
Do you agree that if there is a statute that's enacted by a legislature and a court looks at it and correctly says, if we read it by its literal terms, it would be absurd, that there is judicial authority to say, well, okay, so we're not going to read it to be absurd, not even if that's contrary to its plain language.
So-
Do you deny there is that doctrine, or you think it's not
that
applicable
doctrine
here?
exists. And if this court were presented with the case of me being prosecuted for, shaking or turning around Mr. Kaplan, yes, I would hope that if my office decided to prosecute me, that this court would say no.
But why isn't this case
but-
absurd? I mean, why isn't this case an example of an absurd use of the kidnapping statute when, what was happening was essentially a sexual assault? He was prosecuted for, convicted of, and sentenced for precisely that assault.
I don't think this
14
case-
months more than the maximum penalty on anything else he was convicted for.
So first of all, I do think I'd like to address the penalty question second, if I could, Judge Howard. So in terms of whether this case was absurd, I think the answer is no. This is a case where a woman was grabbed from behind. We don't know just how far Mr. Velasquez Cardozo would have taken her if he hadn't been interrupted by the arrival of the police
He
officers.
wasn't interrupted
And
by
that-
the police. She just got away, right?
No, actually, if you look at the facts of this case, and again, the testimony may not be 100% clear, but what we do know is that unbeknownst to her, when she was fighting to get away, a police car did approach. Now, we don't know because only Mr. Velasquez Cardozo would know really whether he saw the police car, but I think it was fairly inferable from the facts of this case that she may well have been able to get away when she did because the police happened to fortuitously arrive.
But we don't
But-
know then, I'm sorry, but that means that if, you could prosecute if someone's approaching somebody. I mean, you have to rely on the actual holding or detaining to say that that's a holding or detaining, not what might have happened, right? Unless you're relying on the intent to hold or detain,
Right. Well,
which you're not.
I think the intent clause does apply, Your Honor. I mean, again, this court hasn't had occasion to construe just how far or how it would be applied. And it does look like the Red Book Committee basically wrote it out of its model instruction. Congress still has it there, and I think it does play some role.
In this case,
In this
the jury
case,
wasn't
though-
instructed on.
No, it was not. And again, we are not relying on the intent to sustain this particular conviction.
So focusing on what actually happened here, because the
Right.
intent part wasn't tried. And so just imagine this is a case where all you have is there's no intent and it could have been longer. It's just, this is the detention that there was. What's the shortest holding or detaining that you found in any case in the history of, in Anglo-American history that was found to be a kidnapping?
Well, I do think the case from Montana we cited in our brief did describe somebody, a woman who managed to break free after a very short period of time. And the court said,
How short?
I don't recall exactly how short it was. And again, though, I think before that we impose a durational requirement, this court should have a sense of, is it supported by the text or structure, and how long would it be? And I have yet to hear.
Again, if the concern, if the idea is, it's absurd to think that it's a 30-year offense to, hold somebody for a very short period of time. If we thought that, which I know you don't think we should, but if we did, then we don't have to root it in text. It's just, that's absurd. We're not going to interpret the statute that way. So I'm not sure that some of your answers presuppose an assumption that we wouldn't view transitory holding and detaining as an absurd predicate for a conviction. If we do, then that by itself would authorize, I think you concede. I know you don't agree that we should think that, but if we did think that, I take you to say then it's within the judicial authority to say we're not going to interpret that.
I suppose it could, although again, going forward, I'm not sure, given the intent clause, how much imposing a durational requirement on the hold or detain would do, because it is clear that under the terms of the statute, seizing, confining, inveigling, et cetera, with the intent to hold or detain violates the statute.
Well, the duration would be in both parts. It would govern both the actual detention and also how long, if there was a very brief detention and the government was trying to argue, yes, what actually happened was brief, but there was an intent to have a detention. If there's a duration requirement, the intent would have to be for a detention that was long enough to meet the duration requirement. You agree with that?
And if it was, yes, and if it was, one presumably would try to figure that out. Again, though, part of the problem is that I still have yet to hear any durational requirement being proposed that is in the text.
Let me jump in here. There is, assuming that there is some agreement with the notion that if we read the language of the statute as you suggest, without any temporal durational requirement, the result in this case is absurd. You've mentioned that the legislature could, of course, whether it's council and or Congress, could revise our statute here, that there have been attempts and may still be attempts to do just that, and borrow some of the language from the model code and even perhaps go further. I guess what I'm struggling with, and maybe this is not a fair question because we are talking about a particular case here, is what I understand that you are defending the language of the statute as it is and reading it narrowly as you do, and finding that on the facts of this case, we had a sufficient basis. Imagine with us for a moment, if you will, we're sitting on Banc. We don't have to adopt our prior precedent in Richardson, which said that we agree with the interpretation here. Why does your interpretation serve a purpose here? If we read this kidnapping statute as narrowly as you're suggesting for a split-second grope, as we have in this case, what policy purpose, what purpose does it serve? And like I said, I'm asking you to sort of step away for a moment with us from the constraints of perhaps this particular case. And the difficulty I'm having with your argument is the why. Why? Why? I mean, we have some ability here as the en banc court to perhaps see this a little differently. Why shouldn't we? What purpose is served by adhering so tightly to the interpretation that you expressed before the court took this matter on?
Right. So if I could again quote from the Montana Supreme Court, which was considering exactly essentially the same question and asking whether, where someone tried to grab someone, was only able to briefly hold them and they escape, why should that support conviction under that state's kidnapping statute? And the court said the purpose of the statute is to prevent the sort of, I think it was the terror, fear and danger created by someone trying to sort of seize somebody and take away their liberty. I think that is what the text of this statute was getting at, and certainly the way that it has been amended, certainly after 1965, was going after that purpose. I do think that it covers a broad range of activity, from stuff that may be minor to stuff that may merit a severe offense. But one thing I would like to point out, there was a question earlier that came up, I believe, from Judge Deal. Were there mandatory minimums at the time when this was adopted? There were. If you look and I've gone through the 1940 code, and I can't say that I've been able to go through all of it, but at the time, it did have essentially minimum sentences. They weren't called mandatory minimums because they used a different indeterminate scheme, but they did have sentences that required statutory minimums, offenses to maximums. At the time, for example, in 1940, arson had a minimum sentence of 1 year. Grand larceny had one. Grave robbery, oddly enough, had a 1 year mandatory minimum sentence. Murder was
some of the
first-degree murder
statutes
with
that we
death.
see around the country, like New York, and other jurisdictions, maybe they don't frame it as mandatory minimums, but they do have a graduated scale where they parse out the more lengthy, perhaps traditional notion of what a kidnapping is, holding, imprisoning, down to fairly minimal periods of any type of holding. And the sentencing structure or the penalty structure makes that clear.
Yes.
We don't really have that here.
No, we
But
don't.
But we
and-
know that
Right.
it's temporal, well, at least we tend to think that you should be able to read the holding and detaining provisions with some framework of temporality. I don't even know if that's a word, but some time constraints around it
So,
beyond a split second.
I think that brings up an important point, Your Honor. One can, as the model penal code proposed, and as the council recently, passed, it hasn't come to fruition, but it may yet still create a graduated set of offenses, all the way from unlawful imprisonment or restraint, essentially, which carries a much lower penalty, second-degree kidnapping, first-degree kidnapping, depending on the severity of the purpose, I think is how it's really defined. One can do it that way. That isn't how Congress chose to do it in 1933 and then in 1965. But I think it is interesting when you look at how the original sentencing proposal was done in 1933. It said life imprisonment or such penalty as the court in its discretion may provide for. I've looked at the 1940 code and I don't see that formula used in any other offense. The closest, I think, was for blocking roads, where it left it completely to the discretion of the court as to how to set the penalty. It does set it, I think, as something very similar to criminal contempt, which both at the time when when this statute was enacted and to this very day, can carry up to life imprisonment, even though contempt may cover very minor offenses in the courtroom. And it's essentially left to the discretion of the court as to how to set the penalty. The reality is that Congress essentially did fold together here, ultimately, minor offenses like unlawful restraint with things that we would traditionally think of as Lindbergh-style kidnapping.
Can I just ask about, a lot of what we're getting at, and I'm not sure I'm hearing an answer, is there are versions of the words hold and detain that connote a fairly lengthy detention. For instance, I think if you got an SF-86 background check that said, have you ever been detained by law enforcement? You wouldn't start listing every time you went through security and got patted down by security. Am I right about that? Or do you think you would list, or do you think you would be obliged to list every time an officer had, patted you down during a security check going through the airport?
Well, certainly I haven't listed them, so I guess I would agree with you, but it shouldn't normally be read to include that.
And same with the word hold. If my clerk one day called me on my phone and said, I'm being held by the US Marshals up front, and I, went down to check things out, and my clerk came waltzing up the stairs, she said, no, they were just patting me down. It's a standard security check. They wouldn't let me come through without going through security. I think I'd be rightly aggrieved by their use of the English language. Do you disagree?
So I think, again, one can use the words hold or detain in a number of different ways. I agree. I think
And
within the
this-
context of this statute,
I mean, I'll ask a concrete question. You know, one thing that amicus suggests as part of its jury instruction is that the holding or detaining needs to be of a type that one could extract a ransom, which was certainly the intent of the 1933 Congress, right? Because you needed to extract a ransom or reward in order to complete a kidnapping. Why isn't that a pretty sensible way of reading holding or detaining in the kidnapping statute?
A ransom demand can be made in 15 seconds. Take, for example, a child.
So I'm actually really curious about that. So armed robberies happened all the time in 1933 and for some decades after. When's the first time an armed robbery was ever charged as a kidnapping, absent some significant duration, significant confinement?
So I don't know the answer to that, Your Honor.
Would you be surprised if I told you that for 50 years, the answer was never? And
again, I don't know. I haven't done the research myself.
Why do you think, why weren't you guys charging that for 50 years if those were all kidnappings? You were routinely letting Class A felonies slide?
This is 50 years after when?
After 1933. I'm just talking about, you know, I think these sort of novel conceptions of kidnapping as encapsulating, you know, all manner of offenses really started creeping up in the 70s or so. But for, 40 years or so, the government never thought to charge it, which seems tough to reconcile with your view that the plain meaning is that this would capture every armed robbery.
I think Congress, again, as this court has held for example, in connection with the carjacking statute, the general rule is whether something can be charged as more than one offense, obviously is the Blockberger test. Does it have more than one element? And does each offense have an element that the other does not? And it is perfectly permissible for the legislature and to essentially impose multiple punishments under different statutes for the same criminal conduct. That's why carjacking can be charged in addition to robbery or taking property without right.
I have no issue with you there, actually, and I'm not trying to advocate for it can't be incidental or inherent in another offense. I think, as I said in my concurrence, don't find much appeal to that notion. I think it's a little counterintuitive. What I'm trying to get at is if the statute is as straightforward as you think, then why did it take so many decades for anybody to think to charge anything like that, like an armed robbery as a kidnapping?
So I can't answer for my predecessors going back that far. I simply can't. But again,
if you're focused on the District of Columbia, I would think at least until 65 you couldn't, because there was still the extortionate purpose requirement. Now, if you're talking about federal law generally, you'd have to spin back and see what the federal provisions were. But about DC, I would have thought that that there would have been a problem because there wouldn't have been extortionate demands. Maybe, I don't know, not sure. You'd have to look, but.
Right, and ransom or reward, if I could just say, I mean, under the statute, even if we were to take ransom or reward as a durational minimum, I don't think it serves the purpose or does what I think amicus says it would. Because there, for example, if a parent has their child at the playground and somebody walks up and in front of the parent grabs the child and holds it and says, give me $100 if you want the child back, you've just seized and detained the child and you've issued a ransom demand. That I think even under, if that's all that it takes, it doesn't seem to add the sort of lengthy or protracted requirement that amicus and appellant are asking this court to do. If this court is very concerned that our office will charge sort of innocuous conduct as kidnappings, first of all, I think it can wait until we charge actual innocuous conduct as kidnappings. I don't think this is an innocuous case, Your Honor. I simply don't. I don't think ER would say that it was.
Well, look, it's an assault, right? No question about that. I'm going back to the Chief's question of what is the point, right? Like, what is it that the government is getting with charging kidnapping in this case? And my understanding is if we were to affirm in this case, the government would be charging kidnapping routinely in all manner of assaults that involved any sort of seizure, right? Not even just physical seizure, but, intent to frighten assaults that stopped people in their tracks, right? We're going to see an explosion of kidnapping cases if we affirm in this case. Am I wrong?
This court abandoned the Robinson merger test some years ago, and there hasn't been an explosion that I'm aware of since then. I'm not aware that there have been a lot of assault cases that have been litigated up to
The
here.
Banks and Robinson were quite different, right? And so.
Right,
here
I'm
we're
saying
talking
since this
about-
court abandoned Robinson.
I'm talking about endorsing the application of the crime of kidnapping to a transitory seizure that unquestionably is an assault, right? A simple assault. It's a sexual assault, right? There are many crimes that were committed here. The question is whether it was a kidnapping. And if we say, yep, this is a kidnapping too, then the government is going to be kidnapping, is going to charge kidnapping in a myriad of instances. And I think we'll see an explosion of kidnappings. And I'm wondering if the government can assure me that that's not true. And if so, why?
So this court already has held what Your Honor is afraid of. It did so at the panel level. And as far as I'm aware, there hasn't been an explosion of kidnapping.
Why wouldn't there be though?
charges.
That's the second half of Judge Easter's question is quite a good one. So if your interpretation of the statute is right, and leave aside innocent conduct, and maybe that needs to be fixed somehow, but just focusing on duration and assuming there's no sort of incidental non-incidental requirement. In a typical fight where two people end up wrestling at some point and one person throws the other person down, so the person is definitely, seized and held or detained for more than a few seconds. But what ordinarily everybody would have thought of as a simple assault, assume no weapons involved. If we were to affirm here, A, don't you think it would be quite clear that a kidnapping charge could lie in a case like that? And B, if that's true, why would the United States not prosecute it? I don't understand why you wouldn't.
I mean, aren't you supposed to charge the most severe crime that you can obtain a conviction on? So that would counsel in favor of Judge McLeese's.
Right. So I think, first of all, I think part of the problem, and I think what's underlying a lot of the questioning here is the idea that this isn't a kidnapping, that it's somehow unfair to charge kidnapping. But I think the proper way to look at this is an offense under section 22-2001 that goes far beyond what both the common law and popular notions of kidnapping
The
are.
question
that.
still
It's an
stands,
offense.
I
right?
get that thought,
The
but
question is why to charge this crime, right, under this statute that has a
Right.
30-year maximum penalty, is a Class A felony, is one of the few predicates for felony murder, right? Would we see an explosion of these offenses being charged? If so, why not?
Right. The answer I can only say is that although this court abandoned the Robinson test, I think almost 20 years ago, there hasn't been an
As
explosion.
I said, the facts in Robinson are quite different. Or
Right. I
much more
understand that,
akin-
Your Honor.
Much more akin to what one would traditionally think of as a kidnapping. And in this case, you have a transitory seizure. So the question is tied to the facts of this case.
Okay, so
And I
if you're-
understand that the panel opinion, that you're saying there wasn't an explosion of kidnapping charges after the panel opinion, but the panel opinion was vacated when we went on.
No,
So here we
I
are.
didn't say the panel opinion in this case, Your Honor. I said for example, in Richardson, going back to the 90s.
We're talking about applying this offense to these facts, and why wouldn't there be an explosion of kidnapping or of this offense after a hypothetical en banc court affirmed in this case? And if so, why not? Given Judge Schenker's question that aren't you supposed to charge the most serious offense that you can?
Right. So I think, again, you'd have to ask in each case, did the defendant violate the elements of the offense? And if the answer is yes, was there one of those verbs in the first element? And then you have a holding or detention, or if it was done with the
I'm not
intent to
hearing-
hold or
I'm
detain.
not hearing the limiting principle. Am I missing something?
The limiting principles are those in the statute themselves, Your Honor. It
Okay,
has to
so it
be
sounds
the
like
holding
we
or
see a
detention.
lot more kidnappings.
I didn't say that, Your Honor, and I wish you wouldn't put words in my mouth as to that.
Well, I
But
think it's just so you can't have it both ways. Judge McLeese says, why wouldn't you charge that fight as a kidnapping? And almost every fight's going to have some holding or detaining of somebody. I mean, people being tackled, people being grabbed, people being pushed. So it's you can kind of have one or two routes you need to pick. Either, of course, we're going to charge those. Those are kidnappings in our view. Or, actually, as you described it in your original brief, technical kidnappings maybe we'll let slide sometimes. And then the headline is government promises not to prosecute most kidnappings in the district. So, I mean, which is it? Do you think, yes, you would charge that fight as a kidnapping? In which case, I think the implication, you can deny it, but I think the implication is we'd see an explosion of kidnappings. Or no, we won't charge that because why?
I think the answer is if it doesn't look like in the particular case that the defendant was trying to essentially deprive the person of their liberty. In other words, we're just talking about a fight where their purpose is to just fight. It doesn't look much like what Congress was getting.
The guy's trying to get away and I grabbed him back.
Now someone trying to escape from a beating might well be something that looks more akin to what Congress had in mind here, which is that, yes, you're seizing somebody, keeping them from escaping. You are holding or detaining them, and it's for the purpose of beating them up.
What if he's reaching
that
for
might
a
well
weapon?
be.
What if I'm grabbing him back because he's reaching for a brick that's just out of reach, or a gun that's just out of reach in the middle of the fight?
Right. That brings into questions, issues of self-defense and others, which again, I think it does sort of answer a lot of the sort of parade of horribles that's been presented of all kinds of innocuous conduct or things that don't look very serious that might be charged under this, which is that in a lot of those cases, people may have perfectly, good reasons to say, I want to stop somebody from losing their property, like a wallet, or I want to keep them from getting run over by a bus.
Defense would apply in the I grab somebody to alert them to the dropped wallet. Why isn't that a kidnapping?
Again, I think even if it met the literal terms of the offense, I think you would have a necessity defense there. And again,
Why is
I
that?
do
That
think,
seems,
I'm sorry.
one of the necessity defense in criminal law is very limited. And one of its components is that you have an alternative way that didn't involve a violation of the law to achieve your purpose. And if you could have instead said, hey, wait a minute, don't move, your wallet's on the ground there. It seems like in ordinary criminal law, it would be a tough hill to climb to have a necessity defense there.
I do think, obviously, I think, again, this is very fact specific. I do think the more polite way to approach it is not to grab a hold of somebody and say, your wallet's there. I don't do that. I normally would say, excuse me, there's your wallet. I do think there are matters of degree in terms of how much you are seizing or grabbing somebody.
So we
that
need
might
to
well
define the crime, this crime, 2001 to police politeness on the street.
I didn't say that, Your Honor.
Well-
What I would say is that obviously there are choices of means, and I could imagine someone saying, the only way that I could stop this person from losing, their paycheck for the day was to briefly grab hold of them. I don't know whether that necessity defense would be available all the time. And again, we're talking about a lot of hypotheticals of cases that quite frankly aren't going to be prosecuted that way.
Can I ask, one of the things that you noted, and I think that comes through with the different hypotheticals, is this is very fact specific to some degree. And I'm wondering if you would comment on the suggestion by appellant and amicus that perhaps the Berry factors or some tests like that some of the federal circuits have adopted, that sort of looks at kind of totality of the circumstances, for lack of a better word, or more fact-intensive inquiry into duration and other factors. Why wouldn't something like that be helpful in this context where we're grappling with so many different scenarios?
I think the problem with the Berry test is that it essentially creates a different offense. If you look at Berry's factors and where it got them from, although in Berry, the circuit there said it was trying to implement what it saw as the legislative intent, it didn't make any reference at all to the text, the history, anything that any legislator had ever said. Instead, it started looking to the model penal code commentary and state court decisions from other jurisdictions. And all four of its factors are drawn from other court opinions, the commentary to the model penal code.
Would that make
And
it
again-
easier? Would that kind of fact-based inquiry or looking at factors like that make it easier for a jury deciding on,
I don't think it would, Your Honor. I think trying to balance sort of, of all of the various factors that were put out there, which again, wasn't even a specific test. I mean, we usually ask jurors to find, these are the facts you must find.
what about
If you
a
find that you
durational
find them guilty.
requirement? I'm sorry.
Right. So
Would
again,
that help a jury if we said anything less than a half an hour is presumptively not kidnapping? Would that help juries decide?
well, it might make it easy for them, but the question is whether that is what Congress
But counsel, I
tried to
mean,
do.
you started your argument by saying, they're asking us, the other side is asking us to graft things onto the statute.
Yes.
I think you conceded, correct me if I'm wrong, at some point that if we conclude that the statute is written as absurd, that allows us to interpret it. Would you also agree that if there is ambiguity, that allows us to interpret it in a way that inevitably engrafts language into the statute? And if so, I'm sorry, this is a multi-part question. Wouldn't you agree that hold or detain have two or more reasonable meanings, and that gives us an opportunity to interpret the statute?
So I think, first of all, to start with the last point first, hold or detain, Congress used both verbs, and it also said with the intent to hold or detain. So Congress looks like it's being pretty broad there too, just as it was with the first element. It wanted to cover a wide range of holdings or detentions, or actions taken with that purpose. So I think, again, one of the things this court should be trying to do, rather than just sort of think about hypothetical absurdities, but ultimately is to try to implement the will of the legislature.
Right, but that's the question.
Which is
We don't know what it is. Hold or detain have two or more perfectly reasonable definitions or interpretations.
So again, I haven't seen a particular definition that's come out that carries with it any particular period of time. What I'm hearing at times from appellant and amicus is that, well, sometimes detain means custody, but custody, as I think Judge McLeese established during his questioning, could be brief as well. We don't know how long is custody. And even substantial can mean, does that mean lengthy? Does it mean total, as in the holding or detention was complete? Or does it mean that it went on for a long time? So I'm not sure that any of the definitions that are being thrown out there.
What about the chief's proposal? I mean, first accept the premise that a majority thinks that hold or detain means something more than a transitory grab, right? And you've just explained, look, these other terms, substantial, significant, lengthy, they're kind of mushy. What about a presumptive requirement of anything less than an hour is not an offense under 22/2001, because the hold or detain element is supposed to be something that is associated with extended captivity, right? And right, you could have the intent. So the statute allows you to show either intent to hold the person captive or the actual holding or detaining. So would the government prefer sort of a bright line if it had to choose? If it had to choose of 1 hour or 30 minutes or 2 hours, or would it prefer to have some sort of lengthy plus multi-factor incidental dairy factors kind of test?
Certainly, I think if this court wants to actually implement the text of the statute, less mushy factors is probably better than more. That's certainly true. I think the problem with trying to say
I like
1
that
hour
standard, less smushy factors.
I mean, it's sort of the Pullman approach, I suppose, to the statutory interpretation. But I think part of the problem with imposing a time limit at all, though, particularly when Congress didn't put one, is that, to give the example of a ransom demand that's successful within a minute. But that's still, you've seized a child, you said, give me the money. The parents are eager to comply and they give over. But you've still carried out even what most people would think of as a kidnapping at that time.
Sure, but I mean, you're wildly successful and they happen to have the $1 million in cash in the briefcase right there to turn over to you. Great. But, presumably the government could rebut the presumption and say, but look, the bedroom was all set up and, everything was ready to go to hold or detain this child for a longer period of time, and they could overcome the presumption. But it would get rid of these cases that I think, you're hearing a lot of pushback about transitory seizures that may be other crimes, but maybe not are hold and detain in a way that one could interpret 22/2001 to be.
Right. If the question being put to me is like, is that better than non-incidental or protracted from aid, et cetera, things that are very hard to define? Yes, more specificity again is going to be better. I do think that it's rather hard to come up with one and say, realistically, this is what Congress intended. I don't see that in the legislative history. It certainly isn't in the text. And, again, I would say that if there is a problem here with the statute, if the statute is over criminalizing otherwise criminal activity, that's a question for the legislature to fix. And it does appear that the council has moved on that. I don't know what they will
we
do.
think that this statute is really, could result in this explosion of prosecutions, and, is ambiguous and, is absurd in so many hypothetical respects. Should we just strike it down then?
So I think that would be an extreme measure to say that, Congress created something that was just going to be struck down, particularly when we're only talking about, again, absurd hypotheticals. I mean, I don't have it right in front of me, but I know Justice Frankfurter said constitutional adjudication is not served by sort of thinking of all kinds of hypotheticals that are never going to come
I don't
pass
think
in
these
the
are
real
absurd
world.
hypotheticals. These are daily occurrences. I mean, when we're talking about, surprising somebody with a
ones?
hug or grabbing somebody to alert them to a
Well,
drop ball. This isn't like a fanciful, that could only
Right.
happen on Mars type of thing. That's like around the district every day, people are being kidnapped without realizing it.
No, again, I'm not aware that we've ever charged such a thing, Your Honor. And I'm,
Right, but
again, when we're talking
that
about
walks
people.
into the vagueness problem, though. I mean, the whole, vagueness has gotten sort of new breath in the last decade or so with all the ACCA cases and how you define a violent felony. And like one of the more popular lines comes, I think, from Collender saying you can't set a net wide enough to capture everybody and then just let the prosecutors and judges pick out which ones actually deserve prosecution. And when you say we're not really going to prosecute this wide variety of what I think would substantially outnumber true kidnappings, we're not going to prosecute most things that meet the definition of kidnapping as if that should be assuring to us. I find it quite the opposite, quite concerning that the government thinks that, that it's okay for the legislature to punt that decision to the executive, that it raises a vagueness problem.
So again, I think you'd have to ask the question, is that really vague, or is it just that the statute captures or makes criminal a lot of activity? But if it does so in a specific way, it's not vague. Vague means that you would look at it and not be able to figure out what the statute was.
I think it means both. I think it means two things. I think this is laid out in DeMaya and Davis and Johnson, which says that's one thing. You don't understand what it means. The other thing is it's quite clear what it means, but it's so broad that this is the net wide enough to capture everybody, and you leave it to the prosecutors and judges to sort it out. So let's just.
Well, that gets back again. If the concern is that, then I suppose one could think of if conduct was otherwise, that it would need to be at least an unlawful attempt or otherwise illegal activity. So I suppose, again, that's why sort of the hug doesn't become.
But that's also
kidnapping.
atextual, because in 1965, they added otherwise, and that otherwise doesn't make it illegal. So, once we're kind of in the land of grafting something on, why is your preference that we sort of graft unlawful as opposed to lengthy, or, what's your preference?
Right. Again, our preference is that, the statute be interpreted and applied as written. I think that's the first and best fallback.
Can I ask you an abstract question about statutory interpretation and what your position is? So there's been a fair bit of discussion about the absurdity doctrine, and I take it that although you don't think the statute is absurd, at least as it's applied in this case, you agree that in the abstract, if a court concludes that a statute is absurd, it can not apply its plain language into absurdity and say we're not going to follow it to that absurd degree.
Yes, right.
There's another doctrine that's short of absurdity that seems less clearly settled. And that doctrine is the idea that you could, if a court looks at the language of a statute and says, well, there's no reasonable reading of it other than it, that would cover a certain thing. But we are quite sure the legislature didn't intend that. Now, we're not saying it's absurd. We're just saying it's contrary to what we know the legislature was trying to do. There are some decisions of the Supreme Court and this court that say that's another thing that courts can fix and can say, well, we're going to do what we know the legislature wanted us to do rather than what the exact wording of the statute would tell us otherwise we would have to do. And then there's some language in some Supreme Court cases and some of our cases that say, no, that's not really something the judges should fix. That means the legislature made a mistake and the legislature should fix that. Do you have a position on that, to me, somewhat unclear question of what our authority would be if we thought, I don't know if this is absurd, but it's definitely what was intended?
So I do think that courts should be extremely cautious. And again, I understand them. It's always perilous to tell courts what they should or shouldn't do. But I do think the courts should be very cautious about fixing mistakes or perceived mistakes in legislation, because that is ultimately the role of the legislature.
That's
Yes.
I guess a comment on the question, which is, it implies that if we were to do it, we should do it sparingly. Do you have a view about whether it's just categorically out of bounds and really it shouldn't be done, or whether you think it can be done, but should be done only sparingly and cautious?
I'm hard pressed to think of a particular case where I think that's what courts ought to be doing. Again, I'd have to give that some thought, but I don't think that's.
Are Bond and Yates, the Supreme Court. Yates is the fish case. Bond
Right.
is the chemical weapons case.
Right.
I know that, we're springing that on you now. They weren't briefed, but it's two examples.
No, right. I understand. And the Supreme Court has sometimes been willing to step in and say, we're going to excise certain kinds of cases out of this if we don't think that it was really supposed to reach that. To the extent that this court is considering sort of worried about hypothetical situations that this statute could be applied to, there are, I think, varying ways that it could approach it. I do think saying, we're not going to include otherwise innocuous conduct, imposing that sort of otherwise illegal conduct minimum on it would be a better way. Short of that, trying to come up with some sort of temporal limitation would be, I suppose, a little bit better than trying to go the route that Barry took and sort of creating a sort of free-floating balancing test that I think would be very hard for juries to apply. I think those, in those order, that's probably the better, the first, if this court is going to go down that road, if it felt that it needed to, that would be better. I don't think it's needed, and I don't think it's needed in this case. In this case, appellant committed this offense with respect to ER. I think the facts suggest it would have been significantly worse had the police not fortuitously arrived. But I think it created, certainly for her, the kind of fear, terror, and danger that the Montana Supreme Court talked about as
How did it
underlying
create
this
any
offense.
fear, terror, or danger than the sexual assault on its own?
I do think grabbing somebody and essentially, particularly when a stronger person grabs you and deprives you of your liberty, that's a pretty severe thing.
Yeah, I mean, isn't
You're
that
at their
exactly
mercy.
sexual assault, period? I
Oh,
have
no,
to
I mean,
grab somebody to sexually assault.
I understand the sexual assault may be even worse, yes. But for a lot of,
Is every rape a kidnapping? Because
I'm sorry?
is every rape a kidnapping? You're necessarily detaining them.
Not necessarily, because after all, one can rape somebody who is already completely unconscious, for example, a coma patient.
So most rapes are also kidnappings.
They probably are, but that's also true. Most carjackings are also robberies. But as this court recognized, if you apply the Blockberger test, they are separate. And it is
So if
permissible for the legislature to punish both.
Can I take you back to that Montana case?
Yes.
Because I agree, it says what you say it does, but there, my understanding is the Montana legislature had adopted the model penal code with the exception of the substantial requirement, where they excise substantial. So it seems to me there, the legislative intent was quite clear that they didn't want a temporal requirement. And so how does that help us interpret this statute where we actually don't know what the legislature was thinking?
So the model penal code, the only thing I can say is the model penal code was proposed, I think in 1962. The only action that Congress took with respect to, changing the actus reus was to remove or essentially water down the purpose requirement of this statute. Since then, I believe the council did consider adopting the model penal code's kidnapping statute sometime in the 1970s. I don't have it right in front of me right now. Again, you don't necessarily read anything into a legislature's decision to do something or not, but I think the fact that Congress and the council never adopted the model penal code at all speaks at least as much as the idea that the Montana legislature adopted some, but not all of it. I'm not sure why the burden then would be on the government to say that therefore Congress must have intended something like the model penal code. I don't think that can be read into this statute at all. I think the reality is that there just is no durational requirement in the statute. If this court were to impose one, it would essentially have to do so out of whole cloth. Again, I don't know exactly how one would do that and still remain faithful to the text of this statute. And we respectfully submit it's that text which controls, and it is for the council, obviously with Congress's blessing, to fix it if it needs fixing.
All right, any
Can I ask
further
one-
questions? Yes.
One more really short question that I think you probably have a simple answer for. Since briefing was done, we've had recent developments happen. Most of us have referenced the new criminal bill that Congress recently voted down. Should we be taking that in any way? And if we should, how, while we're looking at the legislative intent here?
I think what you can take it for is this. The council is capable, and obviously because of how DC's law works, it does need the blessing of Congress. Well, not the blessing, but just not the direct no. But the council is capable of looking at the statute and essentially coming up with something different. One of the things I think that is important to note in the model penal code itself and also in the proposed statute, it has those graduated offenses: first degree, second degree kidnapping, and then unlawful restraint. Imposing sort of essentially creating limitations on section 22-2001 that make it more like first degree kidnapping, for example, would essentially wipe out any aspect of it that was the old offense of unlawful restraint, and would in fact eliminate something that legislatures have criminalized and the common law did criminalize, which is seizures, in the immediate moment, and holdings, but without asportation and without any other illegal purpose. Congress, in two steps, essentially abolished largely the distinction between what was traditionally known as kidnapping or abduction and unlawful restraint. And I do think that if this court is going to consider changing the statute, for lack of a better term, that it should do so with a mind towards preserving the fact that Congress meant to criminalize a wide array of conduct and leave it to the discretion of the court as to determine how severe of a penalty should be applied. I don't think it would do justice to the text of this statute to essentially say that we are going to write it only with the 30 years in mind. We're going to basically amend this only with that in mind, as opposed to the fact that it has no minimum at all. So I would
sorry,
simply-
I got a little confused. You said Congress abolished the distinction between unlawful restraint and kidnapping.
Practically speaking, it did.
22 so right now there is no longer a common law offense. You were talking earlier about a common law offense of unlawful restraint.
I don't believe it exists anymore. I don't see how you can reconcile that particular offense. And this court has looked at, I don't have it right in front of me, but this court has looked at other cases. Although the code does provide for uncodified offenses from the old common law to still be prosecuted, it is also said that you don't do that if it's clear that statute has superseded it. I do think that unlike in Maryland, where its kidnapping statute looks significantly different, the Maryland courts have said that there is that common law offense still in existence. I don't think that given how Congress amended section 22-2001, certainly after 1965, that there's any room left there for unlawful restraint as a separate standalone sort of common law offense. But I do think that if this court is going to modify the elements of section 22-2001, it should do so with the idea that Congress did not necessarily mean that the only thing that was going to punish was the Lindbergh baby case or a 30-year or something, basically conduct that would merit 30 years as opposed to 0. Congress clearly meant to encompass at least some activity that fell well short of that. And so if this court is going to come up with limitations, it should be with that in mind. Again, we think the statutory text is enough, but again, adopting sort of non-incidental or very lengthy, protracted, durational requirements would do violence to that congressional
Can I
intent.
ask a question? Do Do you also take the position, or has your office taken the position that the federal kidnapping statute has no durational requirement?
Certainly, the government did take that position as recently as the case in front of the Ninth Circuit. Obviously, the
Jackson.
Ninth Circuit disagreed and applied the Berry test.
DC is unusual. Does this create any tension where now there are several circuits that have handed down opinions adopting the Berry factors and imposing some kind of, at least saying duration is something you should be considering, but that hasn't come up in the DC circuit? Is that accurate?
No, the DC Circuit hasn't considered this yet, so no, it wouldn't create a conflict, as I understand it, with the DC Circuit. But I'm not aware that the DC Circuit has ever had occasion to consider 22-2001 after the 1970s. I think it addressed it in one case. I think in 1974, somewhere around there. But after that, or actually, no, I think it was around 1971, but not since Home Rule and the creation of this court as being the final authority. It hasn't had occasion to try to construe that. And I don't think that it's construed the federal kidnapping statute in a way that forced it to grapple with whether to adopt the Berry test. So no, it wouldn't create sort of an interjurisdictional conflict.
Here, yeah.
Not here. Obviously, yes, we understand that the 11th and 9th circuits have adopted the Berry test. We've explained why we don't think that test comports with the text. And so we would certainly urge this court not to adopt that whole cloth.
All right. Thank you, Mr. Coleman.
Thank you, Your Honor.
And we've reserved a few minutes for rebuttal from Mr. Kaplan first, and then Ms. Schneider.
Thank you, Your Honor. Just a few points that I'd like to make in rebuttal. One is the government, as I understand it, the government is saying that, well, it's unusual for cases of a very short duration to be prosecuted. And, one point, it's probably true that it's unusual for those cases to come to this court. But one point I'd make is that I think one of the reasons there's not much obvious evidence of widespread prosecution of kidnappings, I think it's used a lot of times as it was used in this case, sort of as a club in plea deals. It's on the record, my client was offered an 18-month sentence if he had pled guilty. And he could not accept that because we get certain immigration issues he had. But I think with almost any other defendant with a 30-year sentence hanging over their head, I think the government would have succeeded and would have taken the 18-month plea deal, and this case would never have come to this court. One factual point that I want to clarify the record on is there is no, what the testimony is that Mr. Velasquez Cardoso walked up to ER, touched her momentarily, maybe reached an arm around, and immediately turned around and walked in the other direction. There's no.
Can we slow down on that? You're saying he did that without any reaction from ER elbowing him and causing that to happen? You think it's clear that he desisted before she resisted?
Well, the point I'm making is there's no evidence to support the assertion that he did that because the police officer.
Okay, I was just.
You're right. She moved very slightly. She testified she moved her arm, her shoulders, and her elbow. It wasn't really. She didn't describe it as an elbowing, but it was a very. She did not describe it as a detention.
I understand you were directed at a different point. It
Right.
sounded like you were suggesting he desisted before she resisted it, and I take it you're not arguing that.
Yeah, it's not clear if that's. I read the evidence that he would have turned around and walked away no matter what happened.
Well, we read the evidence based on what the jury presumably.
That's correct.
Presumably found, which was, are you contesting that this was a bear hug? That was the testimony, right? That the jury presumably accepted.
Well, it was, I think the argument the government made to the jury that it was at least a grasping. The witness, the victim did not describe it as a hug at all. She said she was touched briefly and her forward progress was interrupted for a moment. But the point I'm making is I don't think, as the government suggested, that this was a there's some reason to believe that the victim's liberty was in imminent danger. He reached around her and she shrugged her shoulders and he walked off. So I don't think there's any circumstances here that would make this different from a lot of other circumstances where kidnapping, I mean, the government suggests it wouldn't charge kidnapping.
What about the government's point that if we add something like substantial, it then becomes lawful in the District of Columbia for a person in the middle of the night to go up and grab another person for a non-sexual reason? Do we worry about that at all? That it's going to leave an area here of activity which
Well, I
sounds
don't.
quasi-criminal, but is not illegal at all because we've limited this statute and there's nothing to take its place.
Well, I think in most circumstances like that, it would be an assault and appropriately punished as an assault. You know, the government makes the point. I'm not quite sure I follow the government's point as to why unlawful detention or unlawful imprisonment is no longer a common law offense. I mean, it's clear from the legislative history, Congress did not know that that offense existed. So I don't see how Congress could have repealed that offense, not knowing that it existed, especially since there's case law that says you don't lightly assume a statute supersedes the common law. Sorry. The government, as I said at the beginning, sort of the whole premise of the government's argument is this statute is very clear. You just look at the words and apply the words. I would suggest that this case is a good example of how that's not true. If you look at the transcript, the jury, the judge, the lawyers on both sides had tremendous difficulty understanding what it was that the statute criminalized. And specifically, the government says there's two separate, so holding and detaining, and then the first list of verbs. Ultimately, what the court did was instruct the jury in response to a note that if the second, the holding and detaining prong was met, the first prong was also met. So essentially, it combined those two prongs into one prong. The point, again, that I'm making is that the statute is not clear. It's an ambiguous statute, and the court needs to decide what it means using the tools that courts normally do for that purpose. Judge Deal mentioned the void for vagueness doctrine, the second prong of the void for vagueness doctrine, that courts are instructed to not interpret statutes in a way that essentially sets a very broad net, which the government can choose to who prosecutes and who not to prosecute. And that's a fundamental violation of due process. And of course, the court doesn't need to get into whether this statute is explicitly unconstitutional, but the doctrine of constitutional avoidance would suggest that the statute should not be interpreted in a way that raises such a serious constitutional issue. With that, Your Honor, unless there are any other questions, I would respectfully request that the court determine that my client was not properly convicted of the offense of kidnapping.
All right, thank you, Mr. Kaplan.
I will be brief. The severe statutory penalty, the legislative history, and the historical context suggest that Congress was not intending to transform every assaultive act into the serious offense of kidnapping with its much more severe penalty. The lengthy isolation that we have proposed would solve this recurring problem that has faced this court and courts around the nation, and it would solve it more clearly than Barry. And it is based on the text, the structure, the history, and the purpose of the statute. And so we, ask this court to give clarity to holding and detaining. And if there's no questions, we will rest.
Thank you. All right, well, the court would like to thank the parties and counsel for your excellent briefing and arguments today. And this was a rather spirited argument with lots of questions. And it's an important issue that we will take under advisement. So thank you all very much for your presence here today. And thanks to our visiting law students and others who have attended the arguments. Thank you.
All right. This honorable court is now adjourned.